on the screen, you can note it if you will.
Recording in progress.
Recording is in progress, so watch out. So we're just looking at Monkey, for instance. Can you hear me okay? He's not nodding. Okay, that helps. Can you hear me better now? I hope.
Yes.
Yes, loud and clear.
Vivian?
Yes.
Yes. Okay,
Yes,
great.
loud
Thanks.
and clear.
Okay, thanks, Valentine.
Yes, we can
All
hear
right.
you clearly
Yes.
now.
Okay.
Yes. Yes, we can hear you clearly now. Yes.
All right. Okay, so thanks all for being with us. And I see here on the banner of the Brussels School of Competition that you are in prison because you have been given a lifelong sentence of learning in your lifelong learning program. There you are. We're happy to be part of it, your third session of the Cartel program, and it's going to be a special one because we have with us Stepan Svoboda, who is with DG Competition, and he's going to help us better understand what goes on in the settlement process that the Commission has developed. The settlement process that is meant to, with benefits for both sides, to cut short, in a way, the traditional cartel procedure. We went through the process already last time. And you will have seen the mention of settlements, but we really didn't go in it too much. Of course, it was mentioned where we looked at the way the fining system is applied and when a potential reduction for leniency, but also for settlement comes into the calculation. So today, Johan and I will be mixing and matching as you are used to. Stepan will come in, you will see, at the 1500 hour roundabouts on settlements. So we have an hour for that. I think the presentation is going to be somewhere between 30-45 minutes, and then a discussion. Anything you ever wanted to know about cartel settlements in the Commission, you now have Stepan to ask the questions to. So first of all, we're going to revisit the fining system of the Commission. I should move to the middle so I can be on camera even. Might help. This better then? I'll stay in this zone. Revisiting the fining system, and we are using this course, highlighting many of the things by the example of cartels. But the fining system is, of course, applicable to all kinds of infringements. So other infringements too, under Article 101 and also Article 102, where the notion of we were not using the notion of relevant markets, but we're using the notion of the turnover concern. The relevant turnover is, of course, a specific question. And indeed, if you look at the fines that Google could attract only based on that notion, in the Article 102 case, of course, you arrive at exorbitant amounts. So there is an adjustment of the system to make sure there are proportionate fines for cases under Article 102, and indeed also potentially other cases under Article 101. I don't know if we can get the Valerie, okay, the little got it out of the screen there for people. Okay, very good. So finding a real life example. So we're going to revisit the little calculation scheme that we had last week. But then having that as a basis, we can go through all the complexities of what comes into holding a company, a group liable for what exactly. How do we deal with, and this is going to be a little bit of entertainment as well, but how are we going to be dealing with cases where a company which is guilty is being purchased by another company either during the infringement or after the infringement, or even after a fine has been imposed already after the infringement? What impact is there from group restructuring on it, which is a very important topic, and indeed to make sure that the fine retains its deterrent effect, we need to make sure that the fine doesn't just disappear in thin air. So we have mechanisms of dealing with these company restructuring situations. Okay, unless there are other comments, questions already now, let's maybe go through that finding system with you again. We'll put it on the screen and see what questions would remain. Okay, I'm just trying to see if this will work. Not yet. Let me try it on this here, or should I click to another?
It's not working. Okay. Share it again. Okay.
Just bear with us for a moment.
Yeah. And you?
Let me try with this, and now, yes, there we go. Super. All right, so let me scroll down on this. Okay, this next slide. Very well. So we had this on the screen last time, just a purely hypothetical and rather easy example using a few rounded numbers. How about again, just bringing you back to the system. Once again, the entry fee you can also use as the fixed amount, which I think what the court has used, and then the variable amount is the other part, which brings us to the basic amount. Now, just coming back to the notions here. So the entry fee is meant to punish the entry into a cartel. So once you're in it, you're going to be slammed with that amount. And we had seen that it is between 15 and 25%. So, there, the commission can vary. Now, in the real life case, the capacitor case that we will just review quickly before going forward to the discussion on liability, etc., you saw that both the entry fee and the variable amount were, let's say, set. The percentage used of turnover was set at 16%, the same for both of these elements. And that's actually what you find in most commission decisions. But it could be, I mean, once again, if the duration is shorter, it may be that, there's a need to maximize a bit this entry fee impact on the fine. So there can be a variation. Now, importantly, again, in the calculation, we departed from 100 million turnover and then used for the variable amount, importantly, the entire duration of the cartel. Now, what is the duration of a cartel? Of course, this was already debated in many cases, exactly, what it is and what it might be. And just to take one example, or to replay an example that may have been mentioned already, when we looked at the definition of the infringement, we had seen already that the attempt is not punishable as such, because it's not a defined notion in cartel law. However, the preparation of an infringement, and when you cross the line of that concurrence of wills, can be achieved even before there is an increase in prices that might result from a cartel infringement. So in the hydrogen peroxide cartel, the cartel had started by the discussions, which clearly had an anti-competitive object, and where the companies were trying to get the market to behave to their liking by trying to get to an agreement first on production levels, then on taking out capacity from the market, and only in a third stage, when all of that didn't work out, they went for a blatant price agreement. Now, it didn't mean that that first part of the period was not included in the cartel infringement. So you look at the full duration. So what you typically find would be a duration of maybe 5 years and 3 months and 7 days, but it's really exactly proportionate to the time in the infringement. And that, so the entry fee and the variable amount, the fixed amount and the variable amount leads to your basis for the calculation, which is the basic amount. And thereby the basic amount is determined for each company individually. It depends on the turnover of the company. Then we had considered whether or not attenuating and aggravating circumstances apply. I think in the case we will just review quickly, the capacitors case, the company got a reduction of only 3% for attenuating. There may be aggravating circumstances such as leadership or obstruction in the investigation, and they are factored in each individually to the basic amount that you have used for your calculation. And then once again, very importantly, you apply the 10% rule then to make sure that the leniency and settlement reductions have their full effect and therefore their full attractiveness to working with the institution, working with the commission. So a leniency reduction, we looked at already the leniency system. If you're the first one in the door, of course, 100%. If you're the second one in the door, you get between 30 and 50. If you're the third one to deliver added value evidence, you get between 20 and 30, and anyone after could get up to 20% of a reduction. So suppose this was the fourth company in the door, they got the full 20% reduction, they cooperated well, and that is then separately deducted as well as the settlement reduction, resulting in the fine based on 100 million, we got to 84. Now, the other example using 200 million turnover here was simply used to make sure that in this calculation, we had an example of the application of this 10% rule. So in the first scenario with 100 million, we would not achieve it because if the group turnover is 2,000 million, 2 billion, 10% absolute maximum of the fine for any calculation would be set at 200 million. Again, and we benefit from the presence here in the classroom, but certainly anyone who is connected online, come in if you can and if you want. The question is, if we apply the 10% turnover rule as a maximum to the fine, which turnover do we look at? The turnover in which year? And does anyone recall what we said last time? I'm looking around the class, but I'm also looking on the screen that is there on my right. Would anyone like to come in? Which is the year that you use?
Last year of the period. Just the year before the.
Exactly. So that's you. So you give the two options, but it's the second one which is applicable. So when you, and the logic is the following: when you impose the fine, the 10% rule is meant to have a protective effect on the company as it exists at that moment. So we use the most reliable figure that is closest to the imposition of the fine, which is the year before the decision is taken. So audited figures in the annual accounts for the year prior to adopting the decision. But for the calculation of the fine itself, so the very starting point is the relevant turnover of the company. And that relevant turnover is meant to assess how bad the cartel was or how bad the participation of this company in the cartel was. And thereby you use the turnover as it stood in the last year of the infringement itself. And we have seen from discussing the process that the last year of the infringement, could be in 2014, but the adoption of a final decision imposing a fine could then be in 2018. So for the 10% rule, you would be using the year 2017, but for establishing the turnover during the cartel, you would use the year 2013. Okay? So this is hopefully clear. Exam alarm, and the reason why is, I will take a few minutes just to take you through also a real life case that I put in the reading materials as a must read. But the must read is basically because we think that it could help you to bring a case to life by going through all the arguments and the extensive reasoning also that the court puts to it in an appeal case against the fine. And as we said last time, it can be directed at proof itself. Were they in the infringement? Did they participate in this meeting? Yes or no? Who was there? Were they aware what the object of the meeting was, etc., etc. But most of the time spent in the defense or in challenging a commission decision in court, most of that time is spent on arguing reductions of the fine and possibly procedural matters. So just for entertainment, let's maybe then, and I may need your assistance again. Valerie, voilà. So this is the discussion that we will have in a minute. But yeah, no, I don't. Oh, voilà. Okay. All right. Yeah, perfect. So I hope you can all see this well on your screen. So a recent 29th of September case, judgment of the general court. So in first instance, and in first instance, you know, all arguments go, all the factual stuff. No, something not working well. Okay, it's not online. Okay, then we get it. We need to do a share screen. Okay, now we are online as well, I hope. And I hope you can all see, and if not, you will scream. And I'm actually looking at the side screen for the chat. Question first, determine the starting amount and a factor, then multiply, talking about the factor, calculate the basic amount. What is the starting amount? So the starting amount that you use, once again, for any calculation that you make, is the turnover of the company. So if they had, like, you know, they sold for 165 million of product X in the year before the end of the infringement, that 165 million will be the basis, and on that you will apply the percentages. So you first need to look at, and these are simply audited data by the company, you know, how much did you sell into the EEA? Now that in itself can be an important debate and an appeal point and discussion in the cartel case, because the more you can suppress the relevant turnover, the lower your fine will be. So that starting amount is, of course, very important. A question here in the room. Yeah.
Yes. So, but it's the turnover within the European Union, right?
It's the EEA turnover. Absolutely. Yes. So that's another big distinction. It's the turnover in the EEA, which is the basis for the calculation. But the 10% protection applies to the group turnover worldwide. So it's not only a different moment in time, but it's also a different notion. So that's an important point, and thanks for bringing that up, because you don't want to get those points wrong when, as we said, you know, the first question that Johan gets asked, if a company is rated, you know, what's the bottom line? You know, what am I looking at in terms of what my exposure will be? And then, you know, you need to know indeed that the 200 million, it's not like the EEA group turnover. No, it's the worldwide group turnover that is the protective level. And of course, for companies that only operate in the EEA or only within a member state, there is no difference. But for many multinational companies, of course, there is a big difference. Okay, now just for, like I said, a bit of entertainment value, but you see already that the appeal case here was on many different aspects. So in the market for electrolytic capacitors and tantalum electrolytic capacitors, we'll just see what they are. There was, you know, it was price coordination, attribution to the parent company, the guidelines on setting fines, were they appropriately applied? What was the gravity of the infringement for this company? Increase in the amount of the fine for repeated infringement proportionality. So a whole host of issues already when you look at the, let's say, title of the judgment. But going in a little bit more deeply, which we will do now, but we'll just brush over it a little bit, but it's more to say, if you want to familiarize yourself with many of the issues that we discussed here, single and continuous infringement, procedural claims, specific role of the company in the cartel, etc., you find them in this judgment, and it's not, you know, an exclusive judgment in the sense that many of the judgments are about the same issues, the same topics, and it's just really an example rather than you know, any particularly good example. But let's just go through it. So here we are with the parent company, NEC Corp. So the fine has been imposed on that company. As I'm trying to scroll down, which now I'm not succeeding in. I will do it like this. Okay. Okay. Then I suppose I can just maybe put the phone or the microphone down here and run you through this. So the infringement at issue, just that you have a bit of the mind's eye working about this matter. Aluminium electrolytic capacitors and tantalum electrolytic capacitors, they are electrical components that store energy in an electric field, used in almost all electronic products as an input. So personal computers, tablets, telephone, air conditioner, refrigerator, washing machines, etc., etc. So the customer base is very diverse. And they are, voila, price is an important parameter of competition. Well, that is no surprise. Then it describes the judgment, the administrative procedure, and I apologize for those who've already gone extensively through judgments. I won't dwell on that too much. The contested decision, it describes what the infringement was about, of course. The liability in terms of direct participation, but then also parent company liability. So importantly, and this is what we will go through still in the discussion also today. And then the calculation of the amount of the fines. Well, just to pause on this a little bit, in order to calculate the amount of the fines, the Commission used the finding guidelines. So, you have the finding guidelines as a must read in your material. Determine the basic amount, took into account the value of sales during the last full business year of participation in the infringement for that company. Okay, then value of sales, the value of sales of this product to customers established in the EEA. So we won't dwell too much on the complexities of other indirect sales into the EEA, but here you have it, the point was just made. And then we had two categories of products, and they applied separate duration multipliers to it. Now, so actually the Commission is calculating two fines. And this is to do justice to the fact that maybe one product was only added on the cartel later, and thereby it also prevents a later claim. Then the value of sales, the proportion, to be taken into account was put here at 16%. And the additional amount was also set using the same percentage. Overall fine on the token jointly and severally. Now I need just to look here. Yeah, so 6 million here. And then the Commission granted 3% reduction. Sorry, I come back to that. So now here we have the scheme that we went through in the table. Here in point 28, the Commission comes to stating what the basic amount will be, from which other reductions are then, or increases are then put. 3% on the ground that the participation in the CUP meetings was not established, as they were not aware of those meetings. So this is the individual role of that company was looked at when setting the fine. And then the increase here is in 30, where the repeat offendership is addressed, and it attracts a 50% uplift in the fine. So a 15% reduction for the leniency notice is then applied, and accordingly we arrive at a fine of 16.5 million almost. So just that you see, it's described here what the scheme of how a fine is calculated is put. Now, then, like I said, for entertainment value, we won't go through everything here, but just to give you the flavor. So, procedure, blah, 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 blah. And here we go. The increase in the amount of the fine for repeated infringement is contested. We have so the derivative nature of the applicant's liability, which is a parental liability. And so on we go, and on we go, and on we go, and on we go with all the case law in relation to all of these respective parts. So, you know, the increase in for deterrence is too much. The repeat offendership might have been there, but 50% is not necessary for the deterrent value of the fine. So court, can you please look at that? Which of course the court does and dismisses. So voila. It then refers to prior practice. Well, the court would basically say, listen, you know, the commission is entitled to change the practice that existed so many years ago. It doesn't have to be the benchmark for what the commission thinks is now appropriate. And again, you know, where you might have the biggest success in bringing these kind of arguments is to compare your case of your client with another company in the same cartel case. That's where the discrimination may be successful, the argument on discrimination, but less so when you start saying, oh, but you know, in a previous case, the commission did something different. We're all very fine, but that's not going to bring you very far. The court only looks at the let's say intra-cartel discrimination. Then we debate whether the 3% reduction would be appropriate, yes or no, and we go on, and is therefore rejected. Also, again, a procedural point always brought up. You might have said 3%, but how do you argue it, commission? Have you motivated well enough? Anyway, here and now, I wanted also to go by, and I don't have it here now, but I will take, sorry, because now we're looking at the parent company case. There's also in your reading material, and I would just get it on my screen myself. You also have the Nishikon case. Well, that goes into the hundreds of paragraphs of a judgment. And just to give you the flavor there, and maybe also the paragraphs that you need to be looking at more specifically, if I can get it on screen quickly, and otherwise I will refer to it later on. No, well, let's revisit that later on, maybe, because the examples are maybe better put also when we've gone through some more of the theory. Okay, let's maybe, you know, just pause here for a moment. So you have pausing doesn't mean a break. That's a different notion. You know, just on the basics of the fine calculation, just want to know if there are any questions on that still before we move into, you know, the higher spheres of establishing liability and continuity of companies. And I don't see any hands up. I'm looking at the chat. If they're attenuating and aggravating.
I have one brief question.
Okay, so sorry, let me just answer first to what Shimon put on the chat. So I hope I understood well, but if you look at the scheme again, you will see that there is, first of all, a calculation for attenuating circumstances of the basic amount. And of that same basic amount, you're going to be looking at whether there are any aggravating circumstances. So one would lead to a minus, the other would lead to a plus. But it's not that you take the percentage first of any, let's say, a reduction of fines, and then you come to a new basic amount, and then from that amount, you then start calculating any aggravation, so any increase of fines. You use the same basic amount to apply both elements to.
So it's addition.
So I hope that's clear, and the same goes for when you have the.
So it's addition, not multiplication.
Again, sorry, Simon.
It's addition and not multiplication. Not multiplication.
Okay.
It's addition and not multiplication.
Exactly. Yes. Exactly. Okay. Jakob, you had a question as well?
Yeah, I was just curious if exceptional circumstances, say such as COVID, would allow to depart from the principle of legal certainty and say, yes, the turnover in this year was much smaller, but it's not a real statement of what the company was making because of such external circumstances. Is there anything of this sort to be taken into account, or legal certainty here is kinky?
No,
so to
I
say?
think it's a very good point, and we haven't gone into that detail here, but there are quite a few cases actually, and the most the most stringent case, if you want, is that where the commission itself decides that the last year of your participation in the infringement doesn't show your real participation in the cartel, because you were in such a dramatic situation that you weren't selling anything. It doesn't mean that your contribution to the lifelong, let's say, cartel, that lasts for many years, should not attract a much higher fine. And if there is an extraordinary turnover year, the commission may resort to another year as a better proxy for it, or take an average of 3 years, for instance, to say what the EEA turnover would be of that company. In other words, what the fine is meant to do is indeed to be a reflection of the company's weight in the cartel, and of course also its overall impact on the economy, and thereby you get to this notion of general deterrence. Mind you, and this all gives the commission space to consider, is that the fine is meant to have an element of individual deterrence. That is, when you look at, and that's where the actual turnover issue comes in, so that you individualize the fine to deter the company because of the 16-20%, what have you, to deter the company from getting into a fine and to punish it for having gotten into a fine, taking away the profit. But then you also have a notion of general deterrence always in the fine, and that the court has often used to say very big companies need an extra multiplier, because it makes sure that the overall deterrence of the fine, imposing a higher fine on big companies, is more, let's say, exploited. So that gives a certain discretion in the setting of the fines as well. Okay, then I suggest we stop here and we go back to the presentation. Yeah, sorry, Judith. Yeah.
Okay, because they're in the judgment, so number 28 is the basic amount, then so maybe you scroll back to it. Yeah, so number 28 is the basic amount, then 29 the attenuating, then 30 the aggravating, and then I can't see the 10% rule. I only see because in number 31, it's the leniency reduction, right?
Yeah, so, but the 10% rule only comes in when it comes in.
Okay, so it's not.
So they haven't gone through, but of course the case team that calculated the fine went through the exercise of saying, okay, but here, since we are looking at, and that's why in many instances, the 10% rule doesn't play a role, because the group turnover is taken as a basis, whereas so the overall group turnover, whereas the fine is calculated on the relevant market of the product concerned. And so unless you would have what we would call a mono-product company, where the turnover of the company is in that product, you wouldn't very easily arrive at putting a fine of, that goes up to 10% of turnover, but it can happen. So you do need to be aware of that and look at it. So, in cartels, in ceramics, for instance, packaging material, which were more like, European, national, local. Local, when I say local, they can be like multi-country, but an industry that operates mostly in France and Germany, which was the food packaging cartel, for instance. So then you might arrive at those situations where the fine that you would impose hits that 10%, which is also, of course, a function of the duration. Though if a cartel has lasted very long, then of course the years mount up. For every year that you are in the cartel, because there you fully multiplied by the year. You don't take saying 1 year extra means 10% extra fine. No, the duration is calculated fully. So for every year that you are in the cartel, you get, let's say, 100% extra on top of the other years. So the longer you are in the cartel, of course, the more the fine mounts up, and then you get to potentially quite, extraordinary amounts, in particular, if you are looking at smaller companies. And that's where the adjustments may come in for, some companies have sometimes claimed inability to pay. The fine would basically kill them. And that's not, what we are after. We don't want to intervene in the market by making companies go bankrupt. If they should be going bankrupt because they cannot, function on their own in the market, then the market should take care of that. And the assets should be bought up, should either exit the market on their own, or they should be bought up by a more efficient producer, which is all great. And if that happens, we apply a very different test. We go to merger control. And in merger control, in the face of sufficient other competition, we generally say, bravo, more efficiency means lower prices. So, mergers generally are looked at very positively, even if there is a prohibition on above certain thresholds of bringing mergers through without allowing the authorities to check. So the prohibition is not a prohibition to merge in a way, but it's a prohibition on implementing a merger without having allowed the competition authorities to check it. And then we can come finally, in some cases, to a prohibition decision. And then that of course happens, but it's extraordinary in mergers. So just to conclude on fining, getting to the 10%, very rare. In the very large majority of cases, I believe we're in like the 80% of cases, the commission fines stay, actually there's some statistical data on the commission's website. I think the fines really stay, below, I think in 70% of the cases we're below 1% of turnover. And then and in like maybe 5% of cases, we are in the bracket of between 8 and 10% of turnover. And sometimes we hit the 10% mark. But still, we put it in because it's in the rules, and thereby you need to apply. But here it simply didn't become visible because NEC was the parent company charged with the violation of an infringement. And if you look at the fine of 16 million, with NEC probably having billions of turnover, well, okay, we move to the next stage, if that's okay. I won't fiddle with the screen. You're better at that.
Yep.
Back to the presentation. Okay. So now you've seen on the program that we're looking at parental liability and succession questions. So here we put the question, okay. It repeats, I think, a bit what Johan had brought forward already in this or in the prior discussion about fines, micro, better like this. So we look at the general principles here of fining, and then we will deepen a few of these aspects. What we need to we use in competition law the concept of undertaking. So an economic entity. We don't use in that sense a legal concept of what an undertaking is. That said, when you impose a fine, you need to find a person, a legal person, to whom you can send the invoice. You need to hold a legal person liable. But we don't want to be held hostage in that sense by the company structure. And just to make clear, with a very evident example, I think the concept of undertaking is an economic concept. Many companies separate their businesses according to product, possibly. They have a separate legal entity dealing with different products, or they do it per country, maybe for tax reasons or other. Or they have, other forms of bringing together. They may have, of course, many intermediate layers also, often for tax reasons that are put there. But a company that decides to split its company according to a legal entity, maybe to say, listen, we also want for to protect the company in case of bankruptcy. If a subsidiary goes bankrupt, we don't want that to affect the whole group. So we're putting that company aside, even if the control structures allow us in the end to take control, to exercise control over the company, over the subsidiary. Another company might decide to just keep it all together. They have business units, but no legal separation between the business units. So, if then you were to take this a few steps further and you were to say, oh, but then, you can only find the company, the legal entity, which was involved in the infringement, then you might end up with a problem, or at least a discrimination between certain economic entities, which have structured themselves according to and separate themselves according to, legal boundaries, and other entities where they operate a more, unified company with certain business units, for instance. Anyway, the relevance of defining what the undertaking is very important also, for, amongst others, for determining the 10% threshold. Now, in calculating that turnover, the 10% threshold, what do you do with joint ventures, for instance? You only have partial control of another company. Does it belong to your group? Yes or no? Do you have decisive influence over their business behavior, over their commercial behavior? Yes or no? So these are questions, that pop up in this regard. And thereby you determine actually what this 10% threshold is going to be, the protective threshold. How high might it go if you rake together all the companies who are in the same group? Deterrence multiplier. So, if you are larger, you may attract more quickly also this deterrence multiplier into your fine. What about repeat offendership? If my subsidiary is assessed to belong to me, I say assessed because it takes often an assessment to see whether you actually have a control structure in place that allows you to influence that subsidiary. Does that mean that the infringement of that subsidiary is going to work against me because in the past I had a previous offender in my group somewhere, another subsidiary did something? So, that might have an impact on this notion of undertaking. Then, of course, the payment obligation. Who is supposed to pay? Is it, parent company? Maybe yes, but maybe certain other entities as well. Are there sister companies? So this is very relevant. And if you've only imposed the fine on a subsidiary and not at group level, maybe you had difficulty establishing that structure, but it impacts on this question of after you impose the fine, who can you go after to get the money? And then, of course, in private damages, who can people go to claim the damages? Where the court has also come out, by the way, on saying, we apply the same notion of undertaking to that question of who you can go to for claiming damages. So with that, I need you again, Valerie, sorry for putting up the little video. Just as an illustration, and it's not a video having to do with cartels, it's pretty old. It has to do with two companies that you might not have even heard about, which shows you how young you are and how not so young we are. But Stephen Colbert, you may still have heard about, the comedian on US television. Voila, and you need to, okay. So I wouldn't claim to say that the Eni example here of the company Eni in Italy is similar, but the reason why we showed you this little clip is that this is something that may happen during the duration of a cartel, when a subsidiary was maybe involved in a cartel, and that subsidiary then gets sold, renamed, repurposed, resold, and might then disappear into thin air, whereas the assets remain somewhere. And this needs to be disentangled throughout the duration of the cartel, because for part of the cartel you may be in as a single company, not singular, but a single company operating. Then all of a sudden a large parent company snoops you up. As from which moment, if we wanted to apply it, does this multiplier for extra deterrence come in? Could you also apply it for the period of time that this smaller company was living on its own? Probably not. So you have to take account of that factor when setting the fine. So you get into all this, this difficulty, and here it's an older case, as you see, but what it's just meant to say, well, at least here the parent company sort of stayed in place. And that's also one reason for us to say we want the parent company as liable, because whatever happened underneath it, at least we have someone to send the invoice to. Because the responsibility of having been in the cartel and the turnover we can probably establish. But here, the Elastomer company, this is the chloroprene rubber business for which a cartel fine was imposed. Around also the period of time that we had the hydrogen peroxide cartel. So you see that the company Anychem and Elastomer were operating. Then they repurposed, let's say, the business, but these two legal entities, then Anychem and Elastomer, disappeared. In the next period, you had thereby Anychem as a subsidiary of Eni operating the business. Then afterwards, they created a new subsidiary called Polymeri, which was then promoted up because the other subsidiary, Anychem itself, disappeared. And then they changed their name into a company called Versalis. And then they changed even the actual business. This, I think, was actually happening after the infringement. So also changes after the infringement, of course, impact on our ability to fine, and we need to see where to send the invoice to. Okay, being mindful of the time, so we had said we will do a short break before 3, which leaves us about 20 minutes to go through some of the complexities of establishing liability. Okay, am I locked again for going forward or not? I seem to be. Yep, okay. All right, so what we're not having enough of, I realize in this setting, with you guys being on screen, but I do ask you to put your questions there, and come in, just shout through your microphone if you want to come in and make a comment. But I certainly also look around the room here, because the question here is, of course, to know when do you hold a parent company liable, but the prior question is, why do you hold a parent company liable? Well, we just went through a few reasons, but there is another dominant reason for this, and this once again has to do with the question of, and we saw it in the case as well, the NEC, they were heavily challenging whether they should be held liable for prior infringement, recidivism. Now, we don't want companies to be recidivists. We want them to comply. So a fine is meant to have a deterrent effect. Deterrence means that you no longer do what you did before, and you make sure that in your family, in your group, in your family, you make sure that all the family members know that they should not be infringing, because any violation anywhere in the family will mean that you as a parent will be held liable with a higher fine. So compliance is really what drives this. And so to hold parent companies liable through the system of recidivism anywhere in the group makes that we believe that companies will ensure that their compliance efforts will be significantly upgraded to ensure that indeed in future, none such thing will happen, which brings you into the wonderful world of compliance, on which there will be a separate session towards the month of June in this program. Now, when do you hold it liable? So of course, there's a legal question there. When can we actually hold the parent company liable? And the court has helped us in that, helped in the sense that clarify the rules, but also has given the commission quite considerable leeway depending on the circumstances. So once again, the key concept, we're looking at the question of undertaking. And an economic unit may, of course, consist of various persons, natural or legal. You know, a dentist is also an undertaking, but it's an actual person running that undertaking. They may also create a legal shell around it. To impose fines, we said you need to go to a legal person, of course. And then importantly, even if the parent company knew nothing and it cannot be demonstrated that they knew, I wouldn't go so far as say could have known, but they were completely outside the cartel. The cartel was happening in a small market in a subsidiary locally somewhere, you know, hidden in Europe. Still, they can be held liable because of this single economic unit concept, which is that the subsidiary carries out in all material respects the instructions given to it by the parent company. And what you often find in real life is that there are claims, oh, but we were not, you know, into the business of the, they were completely on their own, this company. And then, of course, you can start asking questions. But so, you know, who gave this company tax advice for this, you know, who gave the local subsidiary tax advice? Oh, well, that was, you know, the corporate division. Who was involved in their, you know, HR recruitment policies? Oh, well, yeah, for that we have a central department. What about the legal department? You know, was there not a, yeah, no, of course we have a set. So even if commercially on a day-to-day basis, the company might have been able to operate on its own, which often is also not the case because they get raw materials. Where do you get them from? Oh, we buy them from the other subsidiary in the same group. Well, of course you would. So they are dependent there. So there are all kinds of economic links and actual structural links that make it into a single economic unit. But where has the court helped us is the rebuttable presumption. So there's a presumption of liability if it can be demonstrated that you have the ability to influence the company's operations on a day-to-day basis, and the specific legal test we will get to. So if you have 100% ownership or near 100%, that presumption is established, and it's very difficult, if not impossible, to rebut it. And that's logical because once again, if you're 100%, you know, you can hardly start claiming that you are fully independent otherwise, and that there's like a purely shareholder financial link between you. Some companies have still tried in particular circumstances. So what is precisely an undertaking? There's no definition in the treaty. The concept is mentioned, but it's not defined. And here we have it in a case from 2009. The concept of an undertaking covers any entity engaged in an economic activity, regardless of its legal status and the way in which it is financed. The term undertaking must be understood as designating an economic unit, even if in law that economic unit consists of several persons, legal persons, yeah. So the division into national subsidiaries or along products, etc. So, you know, there is a clear difference between the notion of undertaking as an economic concept and the addressee of a decision. So the legal person that the decision goes to. Now, you don't need to look at shareholdership in a way and go through this whole presumption stuff if you have a direct involvement of the parent company. If you can prove the directors in the parent company were aware of the infringement or somehow participated or etc., you know, they are in the game. So then they are already liable on that basis, and you wouldn't even have to go to a presumption in a way. So that's really direct involvement, employees. We have a strange case of Gross where the commission actually got it wrong. The employees belong to the parent company, not the subsidiary. The commission forgot to put the fine on the parent company and lost the case entirely because they couldn't prove the involvement on account, therefore, of those employees. But so, you know, being part of the management of the company is also something that goes, let's say, outside of shareholder relationship, but you can have interlocking directorships between entities. You can have, you know, the parent company actually giving approval, although remaining at a distance. And then the parent implemented certain aspects of the cartel, inclusive of here in the organic peroxides cartel, you know, it was the involvement of the parent company in buying out a competitor in the market, which had been agreed between the cartel participants. Okay, we have to move a bit more quickly. So the actual exercise of the decisive instance, what is that? The reference case is AXO, where the court looked into this in depth. And of course, AXO at that period of time was involved in many cartel cases in chemical markets, notably. The wholly owned proof is all we would need to do. So we can send the company a letter, can you show us your shareholder structure? And then we're there. The problem though arises when that shareholder structure wasn't the same throughout the period of the infringement or changed afterwards. Okay, otherwise we leave this as reference. AXO is the relevant case there. However, the court has not given us total leeway because the court also said, well, hold on, but then the company comes in and tries to rebut it because it's a rebuttable presumption. The commission cannot simply then dismiss it by saying, listen, it was 100% and thereby we don't listen to your arguments. Still, the commission would have to then argue, which is a bit of a strange thing because what does that presumption really do in terms of allowing us to be more quick with our finding if later on we would nevertheless have to start arguing on all the elements that the company brings. But there, unfortunately, we have to address all the elements of defense that companies would bring in so that our decision remains fully motivated. Private damages, as I mentioned, the Finnish asphalt case. So it's basically the same test that was applied there. The parent company becoming liable also for the private damages. This is the example we already showed, the chloroprene rubber case, a court case, I think, from court decision must have been in 2015 on this, but we went through this example, so I won't repeat it. But then the interesting case of joint ventures. And I will maybe just take that a step back before we get there. So what happens if a joint venture, a 50% joint venture exists? What would happen with the fine? So you have a fine that you have calculated. So the joint venture is, let's say you have company A, company B being the parents, and company C is a 50-50 joint venture between these two companies. And this subsidiary was in a cartel. It had meetings with competitors. It was selling chemicals, fertilizer, and they had meetings with competitors selling the fertilizer, but the two parent companies were not in those meetings. They knew nothing of it. Nevertheless, the cartel has found out. Fine is imposed on the basis of the turnover of the product, which was the product turnover within the joint subsidiary, company C, and that has led to a calculation of a fine. There are no uplifts for large companies, what have you. So, all of a sudden there's a fine that comes out of 100 million euros based on the turnover of that company. But we hold the parents liable on and we'll get to that concept, a joint and several liability notion. So it means that we cannot, we cannot rake in the same fine from two sides. So we cannot say, oh, but you are both liable for the fine, because it would mean doubling the fine. The fine is the fine, and once someone pays for that, it's done with. But who of these parents should be paying what? Well, what if you have a 50-50 joint venture? Who has an idea? Any straightforward ideas? If the subsidiary is unable to pay and we need to go to the parent companies to get the money, yeah. So the second part of your answer is right. The first part of the answer is almost right, because that's the direction the court went into. One saying, commission, you cannot double the fine, but you can apportion the fine between the two parent companies. And we said, no. There's only one fine. And based on this notion of being jointly liable for the fine. That expresses the fact that they are jointly liable for one fine, not for multiple fines, jointly liable, but they are also severally liable, which means we can go to any of the three: company A, company B, and of course the subsidiary C. Put differently, we can go to the actual infringing company and get the money there, or we can go to either company A or company B to get the full fine from them. So they are liable on the on the severable basis for 100% of the fine. Think again, compliance, deterrence, it has a logic, but it also has a logic in terms of getting the money in for that infringement. And this is important to retain also for, what's the bottom line? Oh, Mr. Iswin, we only have 50% share in that company. So surely whatever fine is imposed, is going to be cut in half. No. The court once tried to push the commission in that direction, was corrected in appeal. And we don't want to get into that debate of who is between those parent companies more guilty. In a 70-30% shareholdership, that may be a financial regulation. So the 70% in terms of dividends get you more money. But in terms of say over the company, it may very well be that the 30% company has, veto rights and has a commercial influence, which makes that it, for the purpose of the cartel case, makes it, to be in co-control of the subsidiary, and therefore for us, it would become 100% severably liable and jointly with the other companies. So joint ventures doesn't save you unless you really have a minority participation, not giving you any level of control. Yeah.
Just a question there on the potential interplay between,
The microphone, maybe.
Thanks. Sorry. Just on the interplay between, finance attribution on joint ventures and merger control. So, what, for example, the joint venture is a non-full function one. So according to the EUMR, and do we go back to the parent companies as well?
Good question. So the concepts are not fully aligned. And I wonder in this example, but you would have to analyze it for me. Again, and we haven't gone through that merger control analysis in this case. But so we have again, the case we now used a few times, the gas insulated switchgear, where the business of Hitachi and Fuji, who were speaking of complex cases, who were for one part of the cartel in it as separate companies, but then during the cartel decided to put their businesses of the gas insulated switchgear market into a joint venture. And you will see here that the joint venture gave, I think indeed, Fuji a 50% share, or Hitachi, I don't quite remember, and one of those two companies, the other only 30%. And then there was a third shareholder for 20%. And the third shareholder was never in the market, so they never were in the cartel, a financial investor with no control rights sufficient, and under merger control would never have been taken in as, that would never have been a merger case because control was not established. But for this one, question mark. Here, through a multitude of factors, we said they should nevertheless be held liable, but not so much only on account is true on the shareholdership of 30%, because if it's 30%, you need more information. It's not 100%, so you cannot use the presumption. So we had to establish it by other factors. Well, not very difficult in this case. There was a continuing cartel. The company was in it on its own, then put the cartelized business into a joint venture, still with some of the same directors communicating with head office of one of the parent companies. So to show that they were knowledgeable about the cartel, even in the parent company, wasn't very difficult. But in terms of apportioning liability for the period that they were a joint venture, the question arose, can we hold them then to 100% liable for that single fine that we established? And the answer was yes. because we established your responsibility for the operations, let's say, of the joint subsidiary sufficiently to. But here, indeed, they also had voting rights, which gave them a level of control over important commercial decisions. And there, I wonder, maybe on a merger analysis, you would have brought them in to say you need to notify this case because it's actually now a fully fledged joint venture with a joint control structure that gives both parents a say on the market, and therefore the economic impact needs to be assessed on that bigger basis. All right, we are nearly done, but not quite with these questions. And indeed, we have here some practical questions that follow from this. So what happens with if you offer a reduction of fine on this, to whom does it exactly go? How do we disentangle all of that and come up with the most appropriate way to do it? And without going into too much detail, you hopefully see through a bit how important it is to well establish who is responsible in a cartel for which period of time. Then what can you do to rebut? Well, not very much. And Goldman Sachs, in the case that was actually decided now in the court, so went through the general court and then to the Court of Justice, decided in January of this year. Goldman Sachs bought up the power cables business and said, no, but that's, we are just a private equity company in this regard. We just own it for a while and then we sell it off. Well, that's all great. But before you buy it, make sure you go through a proper due diligence. If you find something stinking, come and report it. You will get full immunity for it. But you have taken control of that company, and thereby the presumption applies, and you're not off the hook, even if your shareholdership might have been of short duration. Tough luck. And that again has the, brings with it the incentive to then, comply and find out about cartels and use the leniency instrument. So I already mentioned the notion of joint and severable liability. In French, I think it is something like responsabilité solidaire. Maybe not quite the same notion, but of course, it has an impact on elements of the fine and the fining system, and of course, the 10% threshold can also go up, and thereby we can go to more legal entities to collect the fine. And it's easier, for instance, for our colleagues in DG Budget, who are responsible for bringing in the money to the EU budget. The fines go into the EU budget, are deducted from the member states' contributions. But if we have a subsidiary, for instance, in Europe, it may be an easier target to collect the money from than going to a parent company located in South America. So, for practical purposes, it's also useful to have more than a single entity as becoming jointly and severally liable. Now, a few complexities still, economic succession issues. So we have, a cartel duration. Here, company A is a small company operating in the market, gets eaten up by a bigger company B. And company B then actually continues in the cartel. And assumption 2 can be that company B stops the cartel. Now, if the company B continues the cartel, are they liable? I see everyone here in the room nodding. Of course they are. But if they stop the cartel, what happens to the fact that they bought a company which was in the cartel before? Do they then become liable for that past conduct? And then I see everyone in the room shaking their head, because no, they do not become liable for past conduct of company A. It doesn't mean that they won't feel any fine in their accounts, but they are not held liable for behavior that took place when they were not actually in control. So we could not, in this case, if company B stops the cartel, we could not hold it liable as a parent company. And we cannot therefore use their 10% in the calculation. Important point to keep in mind. If they continue, however, for sure, they are being held liable. And then they attract also the liability of the past, because it's also their involvement that is then at stake. They have simply absorbed it. Now, what happens when you acquire a company involved in a cartel? Of course, you stop the behavior. You know, the subsidiary attracts a fine for the past. Do you have a window of opportunity? You say, I'm buying a company. Oops, I'm discovering they were in a cartel. But it took me half a year to find out. I go to the authorities. I, report for immunity. Lucky you. But if you're not the immunity company, what happens then? Again, GIS is a relevant case where Areva was nevertheless held liable because they bought the business from Alstom, I think. Said, oh, but how could we have known? We were just doing our due diligence in the first few months. We discovered this this ongoing cartel, and how can we be held liable? And then we say, sorry, it was 4 months. Because what differs you from the company who was in there for 6 months or 8 months, or some may have taken a year? You should do that due diligence before. And if you haven't been able to, tough luck. That's how it is. A different decision in a prior case, but longer time ago in the flat glass case in the Benelux. Then, in the scenario that we just saw, what happens if company B buys the cartel? Company A was held liable. They stop the cartel when they buy it. But then they, like we saw in this restructuring with Chem, the elastomer business, then company A disappears because company B says, I'm going to now absorb all this in an existing business unit. And the prior legal entity that was company A will disappear. I could say, oh, well, that's nice. I was never in the cartel as company B. I bought this company. I'm not liable. The company A, which was liable, I've now made it disappear into not into thin air because it's part of my business, but there's no legal entity anymore to be held liable. How nice is that? And you could say this is the German problem, because in Germany, this loophole existed in law and was used by companies and has in the meantime been plugged. Well, we have plugged since a long time, because if the previous, I mean, it can even be worse, but the complexity, we'll try to leave it aside a little bit. In any event, if you buy up a company and then you make it disappear, you inherit the liability for the payment of the fine. So that is, I think, a notion that you should keep in mind. A scenario might also appear when indeed company A was previously held by another parent company. And what happens to the liability of that parent company? Well, that will also remain. It doesn't appear. So we will hold a previous owner still liable for its joint and severable aspect of the cartel when they were owner. I think also, quite an issue, and even when something goes let's say bust, but the whole business, including the assets, are sold, it might still mean that it remains. Okay, couple of scenarios before we stop. I wonder if voila, even when the buyer was involved in the same. Okay, okay, and I think the main thing here, if you continue the infringement post acquisition, you're going to be held liable for that whole behavior. When the infringing company ceases to exist, again, the acquirer can be liable for the period when it did not own the company, as just mentioned. So keep that in mind as well. And all of these scenarios have been looked at in the case law that is mentioned in your slides, and indeed also the private damages aspect there. In case of just an acquisition of assets, so you don't actually buy a legal shell, but you just buy a business, a factory, a building with machines in it, and you inherit that with all the personnel that works on that. It may also be the seller. First rule, the seller will retain the liability. for the period it was the owner. If it continues to exist, if it, however, ceases to exist, if it dissolves, it may still be that the responsibility for the fine follows the assets and not so much the legal shell. Now, our last few slides here, I think the practical advice we have from all of this is, of course, that you need to be, when you go into a cartel case, all of this will need to be disentangled, and you really need to look at who's responsible when, because, for periods when a large company was owner, it may mean an uplift in the cartel. Was there some recidivism that applied to that past period also? Then it may, again, lead to an increase in the fine. So you really want to, look at all the pieces of that puzzle. But one thing is for sure, when you sell and buy, and the Goldman Sachs example is a good one, Goldman Sachs hopefully has covered this problem through the indemnities and warranties in the purchase agreement. So that at least between the companies, whatever the commission determines, they can say, listen, if ever there's some stinky business here that I'm going to be liable for as the new owner, you, previous owner, will be paying for it. And then we can do our business as commission, and they are, at least, from a money perspective, they are safe. They are not safe, however, from being mentioned in the commission decision and getting bad press. Voila. Then, okay, just liability of associations, we don't have to dwell on that too much, but yes, cartel cases sometimes have involved associations within which, let's say, cartel discussions took place, but we don't really have a habit of finding associations. The finding guidelines have specific rules, or actually in Regulation 1 as well, where the 10% turnover limit, for instance, of the association is then the one of the smallest member. But like I said, it's just for reference that we mentioned this. It doesn't really have much practical implication. Now, one maybe big bang point to finish with is the liability of facilitators, which has become an issue in the commission practice with the old Treuhand cases, Treuhand being the Swiss company Johan referred to, and they were distributing colored papers with the benchmark the market shares, etc., in meetings that took place in Zurich. Why colored papers? So no one could cheat in giving them back, because they were organizing the cartel, fake invoicing, fake agendas, etc., to try and cover up the cartel. Initially, a prohibition decision without fines. In a second decision, the commission actually fined AC Treuhand, and now ICAP in the yen derivatives case also attracted a fine against it. So facilitators, even if that is not a definition, but they facilitate, let's say, in the committal of the crime or the violation of Article 101, and thereby are held liable. Now, what does this all do? Compliance, we mentioned it before many times, but all of this is meant to steer compliance. And then the question is often put, why does the commission not give reductions of fines for compliance? And the short answer is that we do, but it means that you comply at least by coming in for immunity. And if you do that, you won't have a fine. So we have a system in place that helps you to comply. Namely, if you do comply, you find out you have an ability to come in for reduction of fines. So there you go. Now, I could dwell on this much more, but it's been a heated debate, and I think you know more about this, maybe you did, also from your company, but I've been in quite a few debates now many moons ago about with and I can name it because it was public, but one of the companies involved in the elevator cartel, who were on a campaign with a number of lawyers also to say, Commission, you're getting this all wrong, because if you're interested in compliance, and companies have done great efforts in trying to make their people comply, but somewhere something has failed and a few rogue employees have done something wrong, you should at least be giving a credit for the companies who have at least tried. Because trying means that there's greater probability that they would come in for leniency. If they do try, it's likely to have a significant success as well. So just to, you know, close your eyes on that and just say, no, 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 we are here to fine, and we're not interested to hear your stories about compliance. That's not the right attitude. You should give some credit to that. And I think personally, that is a very interesting proposition. So we had really strong debates about this. But the other view, the other view you may have on this is, you know, we have two provisions in the treaty and you're supposed to live by them, which is not to collude and not to abuse your dominant position. If you do, if you violate the rules, however well you might have tried, you know, that doesn't get us very far. Now, and I'm not going to dwell on this too much because we will have the whole compliance seminar as well, where we can debate these things more deeply. However, you know, however attractive it might sound to go in that direction, there are two main elements that come into play here. We are working here on a principles-based system, not rules-based. If you have a rules-based system, like in data protection, for instance, or financial markets, you will know exactly what you need to do procedurally to comply. And you can demonstrably say, I have gone through all the steps and I've tried and I've done it. Compliance in competition law is a freebie. That is, companies can do, you know, what they like if they think that's the best for the company to comply. There are no rules, and we don't know also how those companies operate. We don't know their markets. We don't know what their structure is, etc. So it's very difficult for us to assess what good compliance really is. What are the right efforts? So that's certainly, and then the question is, do we want to investigate this? Do we want to spend our time investigating in a competition case whether or not companies have actually complied well or not so well? Where's the benchmark? And then they start litigating that in court, as they would do on the 3% reduction. They want 4 or 5 or 10%. You know, we don't want to get into that debate. We think it's not a debate that we should be having ourselves. We are there for another reason, to expose misbehavior and then to sanction it. So those are the, let's say, the shorter answers to this in itself very interesting debate. Okay, I think we should, but okay, you know, compliance, we think it's a great thing. And we have, you know, also brochures on compliance we have issued, and we have things on our website and all of that, but you don't come to us and ask for a reduction of fines. Maybe final moment for questions, and I've overrun just a little bit in time. So I'm going to beg Stepan for a little bit of patience because we'll have just a quick break. But in the meantime, are there any other questions? I'm looking at the chat. Are there any examples where the presumption has actually been refuted? And I think the safer answer is maybe to say no. The actual presumption, if it's well established, you know, is not going to really be rebuttable in practice. What legal procedure will be applicable in the court hearing proceedings? I'm going to have to refer you to the court, but certainly an important point is that in court, and this brings us a bit back to the procedure, everything is in writing. A competition case before the commission is in writing. We have an oral hearing. Yes, we meet people, we meet the companies, the lawyers, etc. Everything gets laid down in writing, and thereby, you know, this long judgment that we have is all based on the information available in the file, and that's the file that we use against the companies, etc. And the court goes into that direction. The court doesn't generally hear witnesses, even if I can proudly say, even if I wasn't a formal witness, but I appeared in court and they asked me a question about the saga of Solvay and Atofina in the hydrogen peroxide cartel. Who came in first? You know, who made the first call? Who, etc. But you know, that is totally exceptional. Everything is done in writing, so the legal procedure will be run on that basis in court proceedings as well. Last word, in court, and of course, a decision by the commission on a cartel case usually involves more companies, individual finding decisions, etc. So the single document that is a single decision in law is actually composed of different decisions applicable to each legal entity, each legal person that we address in that decision. So when you go to court, you see a cartel case being split out very often in, who knows, 5, 10, 15 different appeals on the same commission decision. Voila, I must stop there. One question still. Yep.
Yeah, so just a quick question. It might be entirely wrong. Sorry, I'm not an expert on cartel. So whenever I read this attribution of liability cases, I'm always thinking on the flip side of the so-called, substantive reach cases. So the court and the commission has been, pushing the concept of decisive influence. For example, in the gas insulators that you mentioned, so that a 30% shareholder with additional rights can be considered to constitute a single economic unit with the parent. But if we flip that, then the substantive reach, they can escape one-on-one liability in the first place because these are internal workings within the single economic unit on a different subject matter potentially. So I'm just trying to see, how far this can be pushed without the boomerang effect.
Well, I personally, I don't quite see the boomerang effect because this notion of undertaking applies to competition law in general. So also other kinds of infringement that might take place, Article 1 or 2, in principle as well, etc. And again, I think what we are just trying to do is to make sure that this notion of economic entity is simply used, and not that we don't get diluted by oh, but this was a separate legal entity operating in a different sphere. Once again, the company structure in terms of how it's legally separated is often very different from business units, and you can have also business units that encompass different legal entities in real life, and the opposite. So I really don't think that we have tried to extract, and I also think it is important again to note that the presumption only goes for the most evident cases. You can't really think that 100% owned subsidiary is then operating independently. Somewhere there must be control. You want to control it, and certainly if it operates under your own brand, which is often the case, that claim really stops somewhere. But other cases, we have to very quickly already. So if we're at 90%, we probably have to prove it on other accounts that there is the actual exercise of decisive influence over that entity. And that's not always an easy thing to do. And in gas installation switchgear, we had to spend quite a lot of time on that to demonstrate what the links were. And it's a whole investigation. Was Mr. So-and-so part of the management board of the subsidiary, yes or no? Were there interactions between the shareholder and the subsidiary? Were they reporting? What were reporting lines? Because reporting suggests also that someone can then say, hey, hold on, you're going off course. I want your commercial behavior to be redirected, what have you. But then the burden of proof is on us. Yeah. Okay.
One last question. You mentioned previously, if I'm not mistaken, that in a case where actually the subject to a cartel fine would negotiate about the amount of the fine in court, they maybe compare their case to a case of another cartel member. Well, general law would probably confront that argument of principle that there is no equality in the bond. Will say that you can actually not say, okay, I have been found. There's another guy that also did something wrong, so he should be fined exact same amount. How is it on a European level?
Well, that is, I think, true to a large extent as well, and that principle is certainly present in many cartel cases. But like I said, the only chance you have of making such an argument succeed is because you have seen the entire file. You've seen the entire file, not only your file, but also the file of the other companies. So you know all the circumstances. You've been to the oral hearing. You have the commission statement of objections. You have the commission final decision. And if then the commission says, oh, but they were in a lesser role because they were not present at these meetings. And you can also say, I wasn't present there either, but they got a 5% reduction. I only get 3%. Then within that same cartel case, you get into the other principle, which is the principle of equal treatment. And that has a chance of success. but it doesn't mean that the notion of the individuality of the fine isn't also very strongly present in cartel cases, within the same case even.
So you might argue that possible discretion has not been executed properly. That there was a mistake in execution.
Absolutely. Yeah. Okay, guys, let's break, but let's do, and I apologize to Stepan already, but let's do a break of a short nature, and let's try to then start at 15:15 on the dot.
No problem.
Yeah. All right. Okay, thanks for now, and see you then in 7 or 8 minutes. Get your refreshments.
Te goed. Verder se vypnout. Te goed. Verder se vypnout.
Stepan, can you hear me? We are testing your sound.
Yes, I hear you. Can you hear me? Yes, I hear you. Can you hear me?
Yes, perfectly. Thank you.
The problem is a bit when I say it, then I hear it twice in 10
So we'll
seconds
start the
time
lecture
again. The
in-
problem is a bit when I say it, then I hear it twice in 10 seconds time again.
Yes, but that will not be an issue because you will present the slide. So I think that will work.
Ah, okay, so it will disappear.
So it will be fine as he will present. Yes, so thank you. It will be fine because you will present the slides and we will listen to you.
Ah, okay, I think the problem would be if you have also your microphone open, and then probably the echo comes back. The problem would be if you have also your microphone open, and then probably the echo comes back.
Yes, it is.
Okay.
It is right.
Okay, good to know. Thanks.
Indeed. Yes, we will switch off our microphones.
Okay, good
Thank
to
you.
know. Thanks.
We will start the lecture at 3:15.
Yes.
Stepan, I have a little bit of a technical question for you.
Yes.
Probably, because you have a lot of backlight, so we cannot very well see your.
Yes.
Okay.
Cannot very well. We can see your silhouette perfectly, but not your face. So if you turn it a little bit, maybe it already helps.
If I'm
That's already better, I think.
this,
Okay. There you go. That's better. That's much better.
If I
Yeah.
move it like this.
Much better. Much better.
Is it?
Yeah. Perfect. Perfect. Okay.
Okay.
Thanks. Okay. So I've eaten into your time. I'm not going to do it now.
okay.
Stepan in the Cartel Directorate and DG Competition, active amongst others on working with the settlement instrument. I haven't shown you the Nishikon judgment. It's in your reading materials. It goes into the tens of pages and the hundreds of recitals, arguments, and in many cases we are able to cut short on that effort because there is a specific tool that we have, and it's the settlement tool. And that's where I stop and I hand over to Stepan, and I thank him dearly for his availability today to discuss this with us. I think as he's just adjusting the backlight, but actually Stepan, the way you had put it was already very good for us. I just think you should put the, voilà, pardon, il faut mettre la, okay, Stepan, this is perfect. We see you very well. So,
Go. Very good.
and we're just putting the.
Go. Very good.
Okay, well, start your introductions as we're getting the slides on screen. So off you go, please.
Thank you. Thank you very much, Ewout. Thank you, Valeria. I'm really happy to be with you, at least virtually, at least online. Many thanks. As always, as our director in the Cartel Directorate, Maria Jaspers, would say, it's important not only to talk to companies and the lawyers during the cartel proceedings, but it's also useful to discuss with law firms, associations, also with young professionals, to enter into debate and to enrich mutually. So I would present you some key aspects of cartel settlements, as we have introduced it already many years ago, and we have built up already quite substantial practice on this. Maybe just to make sure we are on the same page, kind of a warming up question for you. Would any one of you know the difference between these two major tools for the cartel enforcement? So what is the leniency instrument about, and what is the settlement tool about? Would you know the difference? You have probably already discussed this before. Would anyone happen to know the key difference between these two instruments? I don't hear. Maybe it's just my headset. In any case, sorry, now I don't hear. Sorry, can you hear me?
Now?
Yes, we can hear you.
Yes. Sorry, can you hear me?
Yes, we can hear you.
Yes, we can hear you clearly.
Yes. Okay.
Yes.
Good.
Yes, we can hear you clearly.
Okay.
Okay.
Yes.
Okay, Stefan, over to you then. There was
Yes.
one reaction, but
Good.
there we go.
Yes. Okay, maybe I just continue. So
Go ahead.
leniency instrument, it's clearly about.
Okay, maybe I just continue. So leniency instrument, it's clearly about.
And just if you can mute yourself, I would, because I see myself twice.
And just if you can mute yourself, I would, because I see myself twice.
Hear myself twice. Okay, very well, thank you. So for the leniency tool, we are an immunity tool we are basically using to attract new cases. It's for the commission to find out about the existence of the cases, whereas the settlement tool, it's more for the efficiency proceedings. So we can deal with more cases at the same time with the limited number of resources. And we also save the costs for the parties to the proceedings, so we can as quickly as possible to enforce the cartels, prepare the settlement finding decision, and impose the fines and close the case. So overall, the settlement tool is here to bring up the efficiencies, to simplify the proceedings, and to gain some efficiencies in terms of costs for the commission and for the parties, and also in terms of the finality, because in 99% of settlement cases, we will not receive any appeals from the parties, because this procedure is based on common understanding between the regulator and the parties about the scope of the case and about the fines. So if we move to the next slide, then these are the key aspects for the settlements and for the settlement procedure. We use settlements only basically for cartel cases, not for antitrust cases. The settlement is something what we are exploring at the beginning of the case and what we offer to the parties. So it's not that the parties have an absolute right that we engage with them into the simplified settlement procedure. This is always the discretion and decision of the commission, whether we go into the lengthy, more burdensome ordinary procedure, or whether we offer to the parties the settlement route. We have some kind of a scanning exercise, whether or not the settlement route is appropriate for the given case. I will talk a bit about this a bit later. Even if we at some point decide to explore the settlement, the possible settlement with the parties, we still really continue with the proper investigation of the case. First, we need to collect all relevant information for the legal and economic context. And this, so to say, investigatory phase of the proceedings, it's the same. It's both for the ordinary and also for the settlement, meaning analyzing of the immunity application, preparing the inspections, collecting the evidence at the premises of the undertakings involved, receiving and analyzing the evidence received under the leniency applications, some ex officio investigation in terms of further information about the industry, about how the industry operates. We are also sending out some requests for information if we need to learn a bit more about the functioning of the industry, some background information, and also to the parties concerned. about how the cartel was operating. So this investigatory phase, it remains the same. The key feature of the settlement is basically we need to find the common understanding with the parties. The ordinary procedure is very formalized, in particular in writing, and there is less scope for technical informal exchanges with the parties, how both sides see the case. So in the settlement route, the key factor is the common understanding. We engage in technical discussions. Sometimes the discussions are more formal, sometimes less formal. It could be a physical meeting, it could be a phone call, but still it's a free exchange of views, how both parties see the case. And only when we arrive at some kind of a common understanding with the parties about the facts of the case, about its legal qualification, and about the fines, only then we can have a successful settlement. So it's important to see that during these settlement technical discussions with the parties, they will be informed about the key facts of the case, about how the commission would qualify the case, the infringement, and they will also learn about the level of the fines we intend to impose on them. All this before we actually issue the streamlined statement of objection and later the streamlined decision. If there is this common understanding, then the parties are asked to submit at the end of the settlement talks so-called settlement submission. In that settlement submission, they will acknowledge their liability for the cartel. They will agree with the facts, with its legal qualification, and they will also agree with the fines as preliminary established in the form of a range by the commission. So these all aspects the parties to the settlement will know. So they can make a reasoned decision whether or not to agree and to expressly acknowledge their liability. So they will acknowledge their liability in the so-called settlement submission. And the settlement submission is basically the basis sorry. It's the basis for the statement of objection and the decision. On the next slide, sorry. On the next slide, you have listed the key benefits for the commission and also for the undertakings. The key efficiency gains are here that settlement procedure is run in English. There are no translation costs. There is no oral hearing. There is no full access to the file. Because if you have a file composed of thousands of items of documents, then of course it's a very burdensome. So in the settlement route, we just take some tens of documents which we consider as key evidence, and we work only with this limited number of documents. Only to these documents the parties will get access. And of course, this is also less burdensome for them. In the settlement cases, we normally don't expect the parties to appeal. In the 99% of cases, the parties will not appeal. So we will all save also the litigation costs. The benefits
for the undertakings are also clear. They will receive 10% reduction just for entering into settlement with us to save our work. They can save a lot of money for the law firms, for the litigations. They will have a quicker decision, so they can make, basically they can they can turn the page and they can forget about the cartel and continue their business. And they will also receive a streamlined settlement decision, which is very short, with limited description of the facts, which will also help them for the private damage litigations. So if we look into the overview of the procedure and the key characteristic of the procedure on the following slide, then there are two major parts. So investigatory phase, it's the same. We will explore and analyze the evidence we gathered from the inspections. We will send out requests for information. We will also analyze the leniency applications and the evidence. And we will explore firstly informally with the parties whether they are interested in settlement. When we are preparing the settlement, we will of course screen the case to really see if the case is suitable for settlement. I will elaborate a bit more on this. And once we decide, we will initiate a decision, initiate the proceedings against the parties. We will inform also the member states that we initiated the proceedings. And we will also, with this act, close the investigatory phase. So whoever wanted to send a leniency application has to do it basically until the moment that we initiate the proceedings. After this phase, we start the settlement discussions with the parties. It's the start of the prosecutory phase. We entered into three formal settlement meetings and also a lot of technical discussions and exchanges with the parties, exactly with the view to find the common understanding between the Commission and the parties. We explain them how we see the case, what are the key evidence we rely on, and also how we legally qualify their conduct as a by-object infringement, as a cartel, price fixing, market allocation, customer allocation, etc. The settlement talks are done independently and bilaterally with each and every party. This is important. And they are very confidential. So we really discuss separately with each and every party, explaining the facts, legal qualification, and the fines they are facing. We give them the evidence, but not the entire evidence from the file, but only, let's say, the best of the key evidence on which we want to base the case. And the parties, during these exchanges, they react. It's important we have a discussion with them so they can exercise their right of defense. So if they have a different opinion, they express it in the form of documents, non-papers. So there, they express their different legal view or different factual view, and they helped us, so to say, they are involved in shaping the case. We need to hear their arguments. They need to exercise their right of defense. So at the end of the settlement talks, they can take the reasoned decision whether or not to settle. Because they, through the entire settlement procedure, at any given moment, they have the right to withdraw from the settlement talks and to ask the Commission to revert to ordinary procedure. And the same right belongs also to the Commission. So also for us, at every given moment of time, if we don't make sufficient progress, if we believe we are not able to find the common understanding with the parties, or it's very unlikely, we drop the settlement and we revert to the standard lengthy ordinary procedure.
We cannot hear you anymore. Can you speak?
Ah, is it better now?
Hello?
Can you hear me? Ah. So on the next slide, there's the key. What is the settlement? The key document here is the settlement submission. In the settlement submission, at the end of the settlement talks, the parties will acknowledge their liability for the case. They will express their agreement with the case, with the facts and with the legal qualification. And they will also agree with the fines ranges as preliminary calculated by the Commission. So on all these aspects of the case, they would receive during the settlement talks the information from the Commission, the feedback from us about their arguments, their defense, the arguments that we are able to accept, and the arguments we reject. So with these exchanges, they will receive sufficient information to really make the reasoned decision whether or not to accept the liability. Because once they acknowledge their liability for the case, it has also some consequences later on for the potential dispute before the court. And I will talk about this a bit later. So once we completed the settlement talks with the parties, we find the common understanding with them. And they, based on this, they submit so-called settlement submission to us. Based on these submissions, we prepared a streamlined statement of objection, which is roughly 30-page, where we describe the case, our preliminary legal assessment, and our intention to impose the fine. This is already the standard one. And based on this statement of objection, the parties basically only reply with one sentence. We agree with the charges in the statement of objection as stemming from the outcomes of our settlement talks. Just one sentence reply to the SO. And based on this, we prepare a streamlined decision, which again is a very short document, roughly 30-40 pages, with limited description of the facts, limited description and legal considerations, and with a relatively detailed part on fines methodology and on the fines calculation. This is one of the advantages also for the parties, an incentive to settle with us, because in the decision, there is very limited description of the facts and of the collusive moments. And if you, as you know, before the civil courts for the private damage litigations, the claimants, the damaged parties, the victims of the cartel, so to say, they would seek in particular support in the commission decision or a national competition authority decision. So if the decision is very general with limited number of cartel moments and of the functioning of the cartel, this would help the cartelists to better protect them from the private damage litigation risk. So it's one of the advantages why the parties are still willing to enter into a settlement procedure. So if we have a quick look at one of the settlement cases we have adapted recently, a Tallinn case from last year. So here you have basically the summary of all the steps that we need to undertake to successfully complete the settlement case. The case started with the immunity application by Westlake in June 2016. There, Westlake described the key features of the cartel, the existence of the cartel, and also identified the other cartelists. Based on this document and then further information, we prepared the inspections and request for information. You would notice here that it took us almost a year to go out on the inspections. It's normally the time for the preparation is normally shorter, from 2 to 4 months. Here we had a lot of considerations, a lot of also discussions, a lot of legal issues to solve. So that's why it took a bit longer, but normally the time for going out is shorter. Normally following the inspections, the other cartelists with some compliance program, if they would like to cooperate, they submit leniency applications with additional evidence we didn't find at the inspection, something new, this significant added value for our investigation, as Evud has already talked about. So it was shortly after the dawn raids in May 17. So in the summer 17, we received the leniency applications from the remaining cartelists. Normally, 1 year, it's a good time to analyze all the information, to shape the case, to analyze the evidence, to assess how strong we are on the case and on all the aspects of the case. So approximately after a year, always depending a bit on the complexity of the case, but after 1 year, we would initiate the proceedings against the parties if we decide to explore the settlement route with them. We also preliminary adopt leniency decisions, kind of a preliminary view that the leniency applicants were successful. They provided us with a significant added value in terms of the evidence. So that's why at the end of the proceedings, we would give them a leniency reduction. And based or after all these formalities, we would engage in settlement discussions with them. They are normally lasting for several months, up to 1 year, 1.5 years. It's according to my experience, the time, sufficient time to discuss the case thoroughly with the parties, to hear their views, rebut their arguments, or accept their arguments as the case can be. And based on the outcomes of these settlement talks, if we reach the common understanding, the commission is happy with how the case is shaped, and the parties would also agree on the facts and how we qualified the case and how we calculated the fines, then would submit the settlement submissions, this key document where they acknowledge their liability for the case. So this was done then at the end of 2018. And Based on the settlement submissions, we prepared the streamlined statement of objections, 20-30-page document with only a general description of the facts and legal qualification. And shortly after, within few months, we would prepare a streamlined settlement decision, again, 30-40-page document with only general description, which then closes the administrative proceedings. So if you calculate it here, the number of months or number of years, you would arrive roughly at 4 years. Normally, it's, let's say, average time. It's between 3 and 4 years. If you have a look at this timeline, you would see that almost a year we needed to prepare the inspections, which is a bit longer than usual. And also the first half of the year, 2020, we were hit already by the COVID pandemic. So that's why there also we lost some months. So even for this ethylene quite complicated case, we could have reached 3 years, 3.5 years, which would be kind of the average time we would need to process a settlement case. If you then compare with the ordinary cases, I made some notes here, for example, for the optical disk drives cartel, which was initiated in 2009, statement of objection in July 2012, decision 2015, and of course, all parties appeal because this is ordinary controversial proceedings. All the parties appealed, and the court dismissed the appeal, so confirmed the case for the commission only in 2019. So there you see it's a 10-year time if you go for the ordinary procedure, and you need to count also at least with 4-5 years on litigation. So for settlement cases, in 99%, I would not say 100%, but in 99% of cases, the parties are indeed fine with the settlement case, with the settlement decision, and they would not appeal before the court. But of course, if you look at the settlement notice, point 41, it's a standard decision. The parties are individually concerned, they are addressees of the decision. Of course, they still have the right of appeal, and they might do so still before the court. I will talk also a bit later about this issue. On the next slide, just shortly about the settlement screening. Of course, when we receive a case, we are in the investigatory phase. We are sending out requests for information. We are analyzing the evidence, the leniency applications we have. We are also making up our mind whether such a case should be explored in the simplified settlement procedure. We need to assess whether indeed we will get the efficiencies, we will be able to move that case relatively quickly forward, and what are the perspectives of having a successful settlement route, because no one wants to spend 2 or 3 years with the settlement discussions with the parties, only then to find out that the common understanding with the parties cannot be reached, and then after 3 years to revert back and start a full-fledged ordinary procedure. So we are scanning the case, how many parties we have, how many of them are immunity leniency applicants. If it's 3, 4, 5 parties, it's a good number to manage the settlement process. If you have more than 6, 7 parties, it becomes more and more difficult to run 7, 8 separate settlement discussion with so many parties. We assess the evidence. Do we have a strong case? It's clearly by object cartel.
clear-cut price fixing or market allocation, for example, or output limitation? Are the parties playing more or less the same role in the cartel? So there are no diverging interests. They don't have any conflicting positions. Is it a cartel which is limited only to several member states or Europe as such? Or are we facing a worldwide cartel with many jurisdictions around the world investigating the same conduct? Is it a something what we have done already in the past? We have sufficient legal precedents. Or is it something what is really new, where we probably should do it via a standard ordinary procedure? So these are some of the considerations we need to assess before we offer to the parties the settlement route, the simplified procedure. On the next slide, you see that we have already, since the introduction 2008, we have already adapted quite a number of settlement cases from this list. On this slide and on the next slide, you would see that it's independent of the sector. Whatever sectors are suitable for settlement. Settlement is not only for small cases where the fines would be small. If you see the occupancy safety system, 370 million, or very interesting case, car emission from this year for almost 900 million. So whatever sector, whatever size of the case could be quite suitable. Out of many of these cases, at least 10, 12 cases would be from the automotive sector, where there was a wave of cases, 2010, 2012, where many of the suppliers of automotive parts start coming to us, reporting on price fixing cartels or cartels concerning the price coordination and manipulation of tender processes operated by the car producers. So having said this, we have still under the settlement cases different types of settlement cases. If we define them, it's a full settlement. So situations where all the parties to the proceedings decided to submit the settlement submission and to settle the case with us. So full settlement. We have then hybrid settlements. Hybrid settlements are those that some of the parties to the proceedings would decide on settling with us, and some others would decide to withdraw from the settlement discussions and to go into the normal standard ordinary procedure. So with these hybrid settlement cases, we have two types: hybrid parallel settlement cases, where we try to really run the both procedures, settlement and ordinary, in parallel. So at the end, at the same time, we will issue a settlement decision for the settling parties and ordinary decision for non-settling parties. But this clear legal solution is of course legally safe, let's put it in this way, but it would also mean that we need to some extent slow down the settlement. The ordinary procedure takes normally longer, it's more burdensome. So if we want to adapt at the same time, then we need to slow down a bit and lose a bit the efficiencies for the settling parties. So another type of the hybrid settlement is so-called hybrid staggered settlement. So some parties would enter into settlement discussion, would receive relatively quickly the settlement decision, and then the case is closed for them. But with the non-settling parties,
beyond that date, we continue the standard ordinary procedure. And the ordinary decision could be adopted 2-3 years later. So this is for the types of the settlement cases we have. Overall, we can say settlement procedure is a big success. It's really safe resources. It speeds up the procedure. It enables us to deal with more cases at the same time. And it saves also a lot of costs, a lot of burden for the parties. So according to the statistics I looked up, to 70% of the cases in the last 4 or 5 years were done in the settlement route. And the vast majority would be the full settlement where all parties to the proceedings would settle, and not really hybrid settlement, as I discussed. But of course, even for the settlement, it's kind of an ongoing process. We are learning things, we are trying to improve, and we definitely also encounter some of the challenges. So one of the interesting issues which was raised also before the court was in the animal phosphate feed case. Concerned the Team-Up Industries, a company. This company started the settlement discussions with the commission. But at some point, when they learned about the case and they also learned about the fines the commission intends to impose on Team-Up, they withdrew from the settlement talks and they continued in the ordinary procedure. But with the ordinary procedure, they end up with a higher fine than preliminary announced by the commission that the commission would impose fine on them. And of course, the Team-Up was not happy with this outcome and challenged this issue before the court. And it's important here that the court said and repeated after several times, once the party withdraws from the settlement discussions, the procedure, the ordinary procedure, starts anew. So it's a tabula rasa. It really starts from the very beginning, investigatory phase, prosecutory phase, and obviously the legal qualification, but in particular the assessment of the leniency application, for example, or the other fines parameters, also not receiving the settlement bonus, the settlement reduction. All these aspects could change, which ultimately could result into a different fine, be it a lower fine or even a higher fine, which was in the case of Team-Up. So the court confirmed that once we restart the ordinary procedure, we are free to fully investigate the case anew, and then it could result in a different level of the fine. Because what is being said and discussed in the settlement, it's really valid only for that settlement route. If the settlement fails and we revert to the ordinary, everything is forgotten. We cannot use any documents we received from the parties during our settlement talks or the minutes of the discussions or phone calls. They said something, this we cannot use against them in the ordinary procedure. The investigation starts anew. Another interesting issue is with the hybrid settlement cases. We discussed it already before. So in parallel cases, there shouldn't be any big problem in terms of the presumption of innocence, right of defense, because the settlement decision and the ordinary decision are being adopted at the same time. But if you have staggered hybrid, as I explained before, in the staggered hybrids, we first adopt the settlement decision against settling parties. And in few years' time, we adopt the ordinary against non-settling parties. And in the Pometon case, the issue was raised where the party was complaining, yes, but even if I was not part of the settlement procedure, I am quoted in that settlement decision. In the factual part, it creates an impression that already in the settlement decision, the commission concluded on my guilt, on my liability. So this contravenes the principle right of defense and presumption of innocence, because for me, if I opt out from the settlement procedure, then the liability can only be established for me in the ordinary decision, which comes later on. If I mentioned already in the settlement decision earlier, then the commission breaches my rights of defense and the principle of presumption of innocence. So this was the problem which was raised by Pometon. It was addressed with the General Court and ultimately also with the ECJ. And to our big relief, the court still supported the commission when carrying out the staggered hybrid procedure, saying that commission needs to take sufficient precaution when they are drafting the settlement decision. It must be stated very clearly that this decision focuses on establishing the infringement and the liability for the settling parties, and the references to the non-settling parties and their conduct or involvement in the conduct is made only to the extent which is necessary to establish the liability of other cartel participants, of the settling cartel participants. So we need to also avoid to disclose more information beyond what is really necessary to establish the liability of the settling parties. And somewhere in the settlement decision, we did it in a footnote in one case. Maybe we should be more precise and put it somewhere into the body of the settlement decision. We need to expressly also state that it does not concern the liability of the parties that they did not decide to settle. So this was another interesting issue which was confirmed by the court in the favor of the commission. So if necessary, we can still continue with staggered hybrids. But of course, for efficiency reasons, it's the best is always to have a full settlement, to open against all the parties to the proceeding and to have a settlement with all of them. Parallel or staggered hybrid settlement should be only exception. There we also need to wait a bit whether it's more efficient to withdraw from the separate settlement completely and start with all the parties the ordinary procedure. I mentioned when we were talking about the list of the settlement cases that in 99% of the cases, settling parties would not appeal the settlement decision. But in some cases, they have done it. They have the right to appeal the settlement decision, and they have done so. For efficiency reasons, of course, if we find a common understanding with the parties, we expect they would not appeal. In some jurisdictions, it's an interesting reference what the competition authority in the UK is doing at the moment. They are preparing a reform, and they would only settle with the parties if at the same time the parties would agree that they waive their right of appeal, so that the CMA could clearly see, okay, we settle with them and we have a guarantee they would not appeal, they would not drag the regulator to the court to continue the litigation, so that they all can clear the table. So this is what the UK is doing at the moment. It's of course a big question whether even under the European law and the European competition law we could consider something similar. at this stage, we have a clear statement that even after the settlement decision, the parties are free to appeal. We have several cases where one of the parties to the settlement decision appealed that decision. In the envelope case, Printels appealed because when they received the decision, they were not happy with the fines methodology as established by the commission, because the adjustment of the basic amount was done to some extent randomly and differently between different parties to the proceedings. So basically at the level when they received the decision, at that time they could spot it. And they did not like, they felt discriminated, and they appealed. In our ethylene case, which I mentioned earlier, Clariant also appealed, but they appealed the recidivism top-up, 50% increase of the fine because of the recidivism, and they also appealed so-called 10% top-up for the fact that they enter into a purchasing cartel. Before the court, of course, we might argue that Clariant did not appeal something what was unknown to them. They appealed something what they knew that they would get, because they received that information from us already. So it arises the question whether Clariant still behaved in an efficient manner and whether they would still deserve to keep their 10% reduction, the settlement bonus, if they appealed some facts or legal qualifications that they were known at the time when they were submitting their settlement submission. So it's an interesting legal issue, and hopefully next year there could still be the hearings before the court and possible also the judgment, so we have more clarity on this. So this was the last part for the and I don't know if you have some questions now or maybe a bit later. This I would leave for Evut for the organization. Thank you very much. And once more, sorry for sometimes my coughing. I'm still not quite well. And once more, sorry for sometimes my coughing. I'm still not quite well.
Okay,
well, now, Stepan, you have just bought yourself a ticket to come into the classroom next year, and hopefully, you know, in good health. So no, we could hear you very well, and I think we picked up on everything that that you wanted to bring forward. I just want to maybe mention two elements anecdotally, and we put you up on a podium a little bit by maybe referring to one thing, which was an investigation that I was involved in many moons ago in calcium carbide, where we had a Slovenian company involved. And if I say Slovenia, maybe you remember that I talked about the procedure, and how long and how cumbersome it was, also for the fact of translations in that case, where we had to translate the inspection decision, then translate back the inspection results into English, questionnaire back into Slovenian to the company, answer back in Slovenian, translate into English for the case team. Then in the end, we drew up a statement of objections in the Slovenian language. Of course, it had to be translated. Then they answered in Slovenian, which we had to translate back into English to be able to work with it, and then to come to a final decision, which of course they had a right to have addressed in their own language, which had to go back into Slovenian. So you see, quite apart from all the arguments that they could have, you know, that they did make, how cumbersome procedurally such a process can be, and indeed the efficiencies that you get when you're able to cut that shorter. Now, the second reason, and I just wanted to bring us back to the court case of NEC and their subsidiary, which is now the Nishikon case. And if you can just press on the button if we're online on this now. So on the, if you go up a bit further, and you see there start printing in the corner there. You only see it half there. Okay, start printing. And now I think it gives you page numbers, if I'm not mistaken. But maybe I'm wrong. No, it actually doesn't. Doesn't matter. Okay, so this is a full case. And just to make quickly the comparison with everything that you have heard and all the efficiencies that can be gained, I would say, let alone the efficiencies in the actual procedure, but just on the court case, if these things had been discussed and settled, and probably the company could have been discouraged from making a few arguments. But just scrolling through the court case, and just you hopefully start smiling when you see all the elements that were brought forward, the discussion in court on all the meetings, whether they were present, what their role was, etc. The meeting of December 99, and then we go on and on and on and on and on. And that's, until you get to the point where they start discussing all kinds of other procedural elements. We have just entered into the 200s of recitals. We go on. We're now close to the 300s, and still on questions of evidence, a whole discussion by the court, and the question, did the information exchange also concern Europe? And then we turn to the finding of a single and continuous infringement, and on we go. We're now well over 300. And bit by bit, we're starting to get closer to, okay, if all of that, has now been debated and actually dismissed by the court, what about, and also nebis in idem questions. We have the entry fee as well as the variable amount. Do these things not both punish the same thing? So why should you have them double? Blah, 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 blah. And then here we get into the 400s where the actual fines were discussed. Question also, did we publicly distance ourselves, yes or no, by communicating with the other companies in the cartel that we did not want to be part of the discussion anymore? What is the standard there, etc., etc. Well, let's go on for a while, guys. Where are we now? 450. So I was just going to show you the number of pages, but this goes well over 200 pages probably. And finally, after discussing the fines, nebis in idem, the reduction of 3%, etc., etc., we get hopefully somewhere, after more than 590 recitals to the fact, the simple fact that the general court dismisses the action and orders the company to pay the costs. Well, just picture this, in our own workings inside an administrative organization of dealing with all of these arguments, arguing them, consulting with the legal service, going back into the file, digging up the case law, what have you, and compare that to a situation where you don't have all of this, and you can cut it short in the meetings and in the discussions that Stepan referred to. So this settlement instrument has become really, truly very, very important for enforcement. It's a key feature of it. You cannot be involved these days in cartel enforcement without knowing that there is a settlement process, by advising your client to look carefully into it. Whilst, and this I think is important, what you mentioned also, Stepan, the question of, which was debated at the time when I was there, in setting up the system, how can we make sure the companies do not challenge the thing in court? And we could say, well, we will cut off that avenue of going to court, but our legal service said, no way, fundamental right, you must have the ability to challenge the case. So what then can we do? And from the times of the plasterboard cartels, we had a case where the company, in all that process where they could defend themselves in the administrative process, they said, okay, thank you very much for all of that. We've defended ourselves, but now in court, we're going to raise a whole range of new arguments. And the commission said, oh, you guys had your chance. The administrative procedure is meant to bring out those arguments. You bring them into the court case too late. And the general court agreed with them. But this was corrected in the Court of Justice, who said, no, the right of appeal exists, and the parties are free to make any argument that they like in the appeal process whether or not they've made it in the administrative process, with one exception. Elements that have been specifically acknowledged by the parties can no longer be challenged. So the court, at least that is one way for us to say, and in the settlement process, super important that there's clarity and thereby an acknowledgement. So that's why we have the settlement submission of the parties where they say, we agree with this. This is something we have seen and specifically agree with. And they could still take that to court, but then it's very likely that the court will come out and say, guys, you've had your chance. So this is a very important inbuilt feature of the settlement process. But anyways, Stepan, I'm looking whether there are questions here around the room still. There is one, two. I'm also looking at the chat or hands up for the people present online. And please come in if you have questions. And I don't see any questions now on the chat. So we go first to Judith, and then we go to. There we go.
Okay, perfect. So I have one question. As you mentioned, the hybrid settlements. So from a lawyer's perspective, what are the cons of a settlement procedure, or why do companies decide to prefer an ordinary procedure?
Okay, Stepan is noting the question. Maybe is it in the same vein or not? Go ahead. Go ahead. Second question, Joey.
Yes. So in deciding whether or not to go into the settlement, does the Commission take into account the strength of the evidence? So maybe it's a weak case, so maybe then it's easier to settle because you don't have to go into depth into all the details of the facts. Is that an issue that is taken into account or not?
Nicely provoking question, I think. So, Stepan, can you come in on both questions?
Yes. Yeah, for the first question, of course, we need to have a strong case and strong evidence to persuade the parties. And not only the lawyers, but basically also the company's representatives. They are attending some of the settlement discussions. And ultimately, it's the management of the company which would decide whether or not to settle. If we are not really able to persuade them to clearly demonstrate what they have done and what is the legal qualification of their conduct as the cartel, if they are not persuaded that it's our position and we have really strong evidence to prove it, if they are not really persuaded that the fine is calculated in the right manner, that the fine is over the trend, it's not proportional, they still can take the risk and go to the ordinary procedure and later to the court if they feel we are just trying to twist their arms. We are kind of deliberately interpreting the evidence and we are far from the truth. We are far from what actually happened. Another aspect could be they don't have money at this stage. They play on time. You can have also situations where basically they don't want to pay the money now. They try their luck in the process and before the court, and with the hope that maybe in some 7 years the situation will be different and maybe they will pay more or less the same fine, but at a very later stage. Once we had a case that almost at the end of the settlement procedure, they changed the owner, they changed the management, and the company also wanted to do some new business. So they were afraid that if now into that development, it would come an announcement of the commission that they were in a cartel and they had to pay a fine, it would damage their business plan. So even this kind of a business thinking is sometimes behind what the company is considering whether or not to settle.
It's not only strictly legal, but also some kind of a business strategic planning in mind. So a lot of different aspects might come into play. Planning in mind. So a lot of different aspects might come into play.
Okay, thanks for that statement. I think we're going to have to be lenient on our audience here, and maybe we can settle for 10% of an hour of a break, if that's okay for you, Stepan. I thank you on behalf of Johan. There's no break. There's no break. Well, you can stand up, get your coffees, etc. We're going to bang along so we can hopefully finish before 6. Stepan, thank you so much for being with us. Super interesting. And thank you for allowing a deeper look into the kitchen of cartel enforcement in
thank you very much
in DG competition. Thanks. Have a nice weekend.
Thank you. You too. Thank you. Bye bye.
All right. Judith is gone.
Thank you. Thank you. You too. Thank you. Bye bye.
Ja, merci. Ik moet om 15:15 weer even een call nemen. Dus daarom... Oké, we zien. C'est pas facile, hein, ce truc. Now you have to go this one. Okay. So picking up on Judith's question, why do lawyers not like settlements? The main reason why we don't like settlements is basically because you're immediately dragged into the damages procedures. There is actually a benefit to be not in the first round of the damage claims and to kind of wait it out. So it's got nothing to do with whether you have money on your account or not. It may sometimes have to do with business reasons, but the main reason is, and especially because damages, and we discussed that before, can be, a multiple of the fine that the commission imposes. So that's the key reason why a lot of lawyers have become, let's say, a little bit more skeptical of the settlement instrument. Okay, so putting the 3 days together, we've determined there is a cartel. Commission has established a single and continuous infringement. The fines have been calculated, the liabilities have been allocated, and the commission adopts a decision. And then the court process starts. There are 2 courts and I'm blocked. Why am I blocked?
I don't know. I think we are too many on the Wi-Fi.
Well, what?
That we are too many on the Wi-Fi. That's why it can happen, I suppose. I will make sure that never happens to me.
Okay. So this is the lower court. The general court, they have very beautiful blue robes, previously known as the Court of First Instance. There are 2 judges from each member state, plus the registrar. So if you can count, that gives you 54 judges appointed for a renewable term of 6 years. The members of the General Court elect their president, and important, there is no permanent advocate general. The task of an advocate general can be performed in some cases by a judge. In practice, this happens very, very rarely. Now, the general court is the court where you bring your annulment claims against cartel cases, because the general court is the one that deals with actions for annulment of commission decisions. They also deal with a number of other actions that are all identified by the treaty. The higher court, you can see they have nicer robes. They have a court of 27 judges, one from each member state. Again, renewable term of 6 years. Again, president. They do have advocate generals. Now, for those of you who actually want to understand what a case is about, please read the opinion of the advocate general. It is probably the clearest and the most succinct way of understanding the issues in a case. The problem with court judgments is they are written, they are drafted in committee. So you have sometimes 5, sometimes even 11 judges that write a judgment together. And that kind of muddles the waters. It's not always very clear what they're trying to say. Advocate generals give a view. And there are advocate generals that are very, very outspoken on, for example, on cartel issues. Advocate General Kokot, for example, the German advocate general, is notably very outspoken on some of the cartel issues, can be very harsh on the commission. So that's always my view. I know it takes a bit of time, but it's a fascinating read. Again, in the context of cartel cases, the Court of Justice will intervene in cartel cases in 2 ways. The first is as an appeal court to the general court. So the Court of Justice will hear appeals on points of law, but also and more on the basis of references for a preliminary ruling. So national courts that are confronted with cartel issues, with questions about, is this an object infringement on the basis of Article 101, can actually ask for a preliminary ruling to the Court of Justice. They can ask for advice on the interpretation of Article 101. And again, it's the European Court of Justice that hears those references. The scope of review. What can the General Court do? The General Court has jurisdiction in 2 respects. First, it reviews the legality of the decision, compliance with the duty to state reasons, so motivation, infringement of which renders the decision liable to annulment. And secondly, the appropriateness of the amount of the fine. So they look at the substance of the decision and they look at the fine. The standard of review by the General Court is very simple. It's basically, has the Commission proved its case to the requisite legal standard? And in one of the rare cases where the president acted as the advocate general in the General Court, he said, what we need to do as court is we need to perform an unfettered evaluation of the evidence. We actually need to look at the evidence that the Commission brings us. And the evidence must be reliable. It must be probative. It must be precise. It must be consistent. And it must be sufficient. And the court says, look, it's complicated. We all know that. Cartel cases, a lot of it is hidden. But you need to look at the body of evidence as a whole. And in Keimer, actually, the court goes into even more detail. The court says, look, the Commission must be sufficiently precise and consistent. Any doubt in the mind of the court must operate to the advantage of the undertaking. There has to be a body of evidence. And the court acknowledges it's not easy to be the Commission in cartel cases because, these meetings take place in a clandestine fashion. They're secret. There's no documentation. The evidence is fragmentary and sparse. Often it's basically on the basis of coincidences and indicia. So it's not easy to be the Commission, but my role as the court is to test
that. The court has a particular focus on immunity and leniency applications. So immunity and leniency applications are important, but, says the court, they're not sufficient on their own. So the statements must be corroborated by other evidence. So that gives you kind of the framework in which the court will be looking at commission decisions. Now, very important, if you ever have to appear before the court, there are 4 grounds of appeal. They are set out in the treaty, and you have to kind of squeeze your arguments into those 4 grounds of appeal. The first one is legality, lack of competence. That's kind of a ground that you don't use very much anymore. I call it the commission really fucked up ground. So to give you an example, a case that was annulled on this basis was PVC, where the language versions had not been adopted by the college, but they had been adopted by one commissioner. That's a fuck up, right? I mean, clear. Or even worse, soda ash. The commission adopted the decision, and DG Com decided that they wanted to make some changes after the adoption of the decision by the commissioners, and basically it came out in court. I mean, those are like massive procedural errors. Recent cases, this ground hasn't been used very much. This one is very important. Procedure. The court loves procedure. So basically, if the commission has not respected an essential procedural requirement. Essential is, it basically makes, has an influence on the content of the decision or deprives the undertaking of the possibility to control legality. In practice, there are 2 claims that come here. The first one is one which is very often used, is motivation. The commission needs to motivate. When they say something, they need to justify what they're saying and how they support it. That is an essential procedural requirement. It's kind of a bit weird, right? I mean, is this really an essential procedural requirement? Yes. So motivation is under that heading. And then, of course, everything that has to do with rights of defense, right to be heard, often issues in relation to the statement of objections, access to file, will be under essential procedural requirements. The third ground of appeal is what I call infringement of the treaty. That's all the stuff that we've been talking about. Things like general principles of law. Is there an agreement? What is the undertaking? Liability, imputability, single continuous infringement, all of the stuff that we've been talking about. If you feel that there is a wrongful analysis, that basically is under this heading, infringement of the treaty. But also errors in fact. So if the commission, if you believe that the commission has misinterpreted evidence, that the commission has not respected the beyond reasonable doubt threshold, and as the court already said in Keimer, the benefit of the doubt must be given to the company. So either error in law or error in fact. That's the third ground of appeal. And then the fourth one, I'm not going to go through these 2 because those are just cases. The fourth one is the review of the fines. Review of the fines, the court has unlimited jurisdiction. And you remember the case that I mentioned last week, the BASF case, where actually the ultimately, because the lawyers fucked up, the fines were imposed higher than before. Well, that's a phrase that the president once used in court. The elevator can go down, but it can also go up. So those are the 4 grounds of appeal. Review of fines. The discretion of the commission is limited by all of the things that we've been talking about over the last 3 days: 10% threshold, general principles of law, the case law of the courts, and the fining guidelines. And again, this is an example of a case. I'm not going to go through the examples just in the interest of time, but you can read them in your own time. Now, Then the Court of Justice. So we've just done the General Court. The General Court is the court that deals with facts. The Court of Justice does not deal with facts. The Court of Justice is way too above the facts. So they are dealing with errors of law. So again, things like liability attribution, interpretation of Article 101, single and continuous infringement, and the procedural issues. Again, the Court of Justice loves procedural issues. They will also look at the fining calculation within the same limitations that I mentioned for the General Court. They will actually check whether the General Court has correctly interpreted their fining kind of constraints, and the General Court has exercised its unlimited jurisdiction within the boundaries of the general principles of law. So the Court of Justice has a very different role. So if you ever go to the Court of Justice, do not start referring to evidence. They get very annoyed when you do that. Okay. A couple of years ago, I clearly had nothing much to do with my life. And I looked at all of the cartel judgments that had been rendered between 1988 and 2004. And what I tried to do was to see what are the arguments that the court is confronted with. So what arguments are the parties bringing to the court, and what arguments are successful? And I defined it into kind of four categories. So the procedural issues, the legal issues, single and continuous infringement, liability, the factual issues, and then the fining calculation. Those are actually the key points that I mentioned as grounds for appeal. And what I noticed was that actually it was pretty balanced. 25% procedural, about 11% legal, a lot of it factual, and then unsurprisingly also a lot of it fining. But what surprised me was when you look at the evolution over time, because in the period between 1988 and 1995, and then the second period, 96-2004, procedural and legal were pretty much at the same level. But what you see is that suddenly the factual claims drop very dramatically in 1996, and the fining one goes dramatically up in 1996. Why?
Fining guidelines?
Almost. Not the fining guidelines, other guidelines. The Commission introduced the leniency instrument. So suddenly, you couldn't debate facts anymore because there were like 5 people that were saying, you are guilty. Jakob, you did it. So there was no point in going on facts anymore. So the only way that you could still try and attack Commission decisions was on the basis of the fine. The procedure. The procedure before the General Court starts with an application, which needs to be made within 2 months of the adoption of the decision. In a number of cases, you can ask for interim measures. You will never get them. Interim measures is basically, please suspend the payment of my fine. You'll never get that. There is then a written procedure. Sometimes member states can intervene if they believe there is an important role or an important legal issue for them. The juge rapporteur, the reporting judge, because one of the members of the panel is actually following the case much more directly than the others, will write a report. You will get that report. There is then the oral hearing, and there is the judgment. As I said, apply within 2 months. If you're not in Luxembourg, you get an extra 3 weeks. Please don't miss the deadline. If you miss the deadline, you're out of time. The average time between the application and the hearing is about 29 months. And the average time between the hearing and the judgment is about a year. As you can see, the longest cartel case is still Greek ferries. That was 5 years before the General Court. The application cannot be longer than 50 pages, 50. There is then a defense by the Commission. You then get the reply, and the Commission gets the last word by rejoinder. If you ever have to appear before the General Court, please read the rules of procedure. There are very, very, very detailed, very annoying and very tricky little rules that have to do with the lines that are supposed to be between the sentences, the font that you need to use before the court. It's all very standardized. So you're not necessarily inadmissible if you don't follow those rules, but the registrar will call you and say, please do it again because you haven't complied with rule number 7, 8, 9, and 10. So it's going to actually spare you some time. There are practice directions. There is a advice to counsel appearing before the court. There are actually hearing rules. So it's a very well, I would say, structured process. The court helps you quite a lot. You can call the registry. I actually sometimes do that. You can call the registry and they help you in your appearance before the court. As I said, interim measures, it's mainly around suspension of the payment of the fine or the obligation to provide a bank guarantee. It's almost impossible because the threshold is so high that it's basically almost unattainable. You have to show that it's objectively impossible for the applicant to provide a guarantee, or the provision would imperil its existence. Bonne chance. This is the court. The left is the General Court and the right is the ECJ. And basically the middle bit is where you go in. This is a General Court hearing room. And this is a General Court hearing room in action. So normally the applicant sits on the left and the Commission sits on the right. In this case, you would normally also have a number of what they call référendaires, so legal secretaries that help the judges in the drafting and in the analysis. Now, oral hearing. You have 15 minutes to make your oral argument. There is a really, really strange procedure, which is when the court starts the hearing, the lawyers are being called into the antechamber. So there is I should actually show you this. There's a little door here, and the judges are behind that door. And so you're called in, and it's supposedly you're introduced to the judges. The judges will say, or the registrar will say, this is Mr. Iswin, Mr. Cherovchek. Allegedly it is to be nice, but it's actually horrible, because the court at that moment will tell you, Mr. Iswin, you brought 5 main bases of appeal. Number 1 and number 2, forget about it. We want to hear about number 3. So actually what you need to do is you need to prepare your oral argument on all of these bases, and then basically throw away what you're not gonna plead. The oral hearing basically brings everybody together. So the applicants, the Commission, and the interveners. There are lots of questions. So the idea is actually it's a trial by questioning. It's not a trial by pleading. So, I mean, my experience is the plea is actually not that relevant, but you really, really have to get up to speed on any possible question that they can throw at you. Very important, if you ever appear before the General Court, it is likely that a number of judges will not understand the language in which you're pleading or answering. So they'll be listening to the translators. Don't be funny. I've tried that once. Jokes don't translate well. So you then suddenly see the Estonian judge looking at you like, what? So very important, but make your make your plea also and answer your questions in a coherent way. And also don't speak too fast because the translators can't follow. Often that's the case with, and I don't want to kind of criticize anybody in the room or on the screen, but you often have that with people from the South. Italian lawyers, Spanish lawyers tend to kind of go relatively fast. And then you see the translators kind of, waving in despair. It's a big circus. It's fun to do, but it's a pretty stressful experience. The procedure before the Court of Justice is exactly the same with one difference, and that is the opinion of the Advocate General. So application, you can also ask for interim measures, written procedure, intervention, report for the hearing, there's oral hearing, and between the oral hearing and the judgment, there is the opinion of the Advocate General, which is, I think, the main difference between the General Court and the Court of Justice. This is the main hearing room from the Court of Justice. You can see it's a little bit more grand. Now, winning isn't everything. And that was a mistake I made when I came from the first time back from the court. And I think it was 9 months later, we got our judgment in and I won on motivation. So I was very proud of myself, opened a bottle of champagne, called the client, we won, yay, we won. And then 3 weeks later, I got a request for information from the commission saying, not congratulations, you won, saying, we lost on motivation. So we're going to readopt the decision and we're going to motivate it better. So please provide us with the following bits of information that we're going to include in our readoption decision. So what you often see is that when the commission loses on procedure or on motivation or on errors in the finding calculation, that they then readopt. The commission are very sore losers. Now, there's something I'd like to discuss with you. And it goes back to a point that Ewout made. And I think it really goes to the heart of cartel enforcement in the EU. So you have this body, the European Commission, and the European Commission basically is the investigator, they're the police, they are the judge, they are actually also the executioner. And there is a really important question about whether that is indeed in line with Article 6 of the European Convention, which ensures a right to fair trial. And in Menarini, the court in Strasbourg said, in order to ensure compliance with the fundamental right to a fair trial, in the case of a competition authority that can do all of these things, there has to be a court, and that court must have powers that can fully review the decision of the administrative body. And what the court said is there are a number of steps that we want those courts to be able to do. They need to examine the applicant company's various allegations in fact and in law. They need to be able to examine the evidence. The role of the courts has to go further than just verifying lawfulness. They have to be able to verify whether in the particular circumstances of the case, the authority made proper use of its powers. They need to be able to examine whether the decisions have been substantiated and proportionate. And the review needs to be carried out by courts having full jurisdiction, insofar as the administrative court are able to verify that the penalty fits the offense. After all I've said, after all the descriptions I've made about what the General Court actually does, do you feel that it does those things? Who feels that it does those things? Nobody? Oh, the court will not be happy. What do you feel it doesn't do? It clearly does this, right? I mean, it has full jurisdiction over the fines. There's no debate about that. I mean, they can examine the various allegations in fact and in law and examine the evidence. And the only one that I can see some discussion is the second one. You know, has the Commission made proper use of its powers? But I'll spare you the pressure and the clear stress that you're now under. Actually, the court in Strasbourg has confirmed that the General Court and the Court of Justice comply with these criteria and therefore comply with the fundamental right to a fair trial. Otherwise, I think we would have probably changed the system. So, I mean, that's basically the court process. I hope you never have to do it. It is, I always say when you get before the court, you've actually lost your case because you haven't been able to convince the Commission of your arguments. But if you do, and some of you may, be as, I say, as open as possible with the registry. That will help you. You can always call me. I've had people who I talked to 9 years ago who sometimes give me a call and say, hey, you know, how does this work? So don't hesitate, but it's really important you get it right. Because obviously if you apply and the court says, sorry, but it's inadmissible, then your insurance company will not be happy. Now you can take a break. And then Ewout will talk about the international kind of elements of cartels. And I think we should be able to end a little bit earlier than usual. Thank you. I paid Valerie to do this.
No.
Uh,
10 minutes?
Yeah, 10 minutes, yeah.
Okay. Hi everyone, can you please come back to the lecture? Here it is. Okay, so that worked fine, and I will ask the yeah, it's ready.
Okay, everybody, welcome back, welcome back. Last stretch. And up for a bit of discussion. So I'm going to be also asking you to come in. And I know that, you know, there are some maybe mental blockages when we see people only with their names on the screen. In order for me to connect to you or you to connect to us here in the room. But of course, we have luckily a live audience as well. Composed even of creatures on 4 legs. For a bit of livelihood here. So I'm going to ask you to come in, maybe also with some more opinions at the end of this and the end of these 3 weeks. This session, three parts session on cartels, and we're going to be closing it off with some international reflections. So we're going to take, you know, hover a bit over what we saw today, and we let's say step a bit out of the morass of court reviews and settlements and fine calculations and all of that, and look a bit more at how the system really operates in a European and also international context, and maybe also to see whether there are changes, you know, also concerning, let's say, the direction of travel of the cartel instrument towards the future. So a few topics that we will cover in the remaining, I would almost say, minutes. We'll try and take, you know, the shorter part of half an hour to go through this. So, you know, that there are any final questions. Whereas I suppose one of the final questions you are dying to ask is, when can we please leave and when can our weekend start? So we'll try to have that happen really, really soon. So a few aspects still. So if Europe does the things its way, or the European Commission, how does it fit with the bigger international picture? What do we need to take account of in setting our policies? And one of the things that you heard already today in settlements, for instance, is this interplay with damages actions. And so here we're going to be looking a lot at, you know, how do the systems interact, how they can, you know, be optimizing themselves in a context of, you know, leniency cooperation worldwide. How do we make sure we don't damage each other's investigations by, you know, not warning the others that we're going to go in and find an international cartel, and then really, you know, spilling it for the, or spoiling it rather, for the other investigative authorities, because then the cartelists will already know that the authorities are looking. So how do we keep each other informed? Can we exchange evidence if we are working internationally with different kinds of systems? Fact gathering based on a criminal standard is really going to be different from what you can do in an administrative system. And can we then freely exchange evidence, yes or no? What about sanctions? You know, pecuniary sanctions, adding up the millions and the millions, isn't that over deterrence? Should authorities collaborate with each other to see what an appropriate sanction would be and look at the overall picture? Again, what about damages actions going forward? If we want to introduce that or work with or around damages actions, what are the implications for public enforcement? And should we not be putting some stakes around this to make sure we keep the incentives in place? And lastly, also, there are still calls for saying, oh, but this is white collar crime. If you're in a cartel, if you're in a bid rigging case, why is the cheating that you do there not as bad as fraud, as bribery, where generally we have put criminal sanctions on those kinds of infringements? Why don't we do that here? And some would say, well, we have already done it. It's happening in other jurisdictions in the US, and why don't we simply copy that into the European sphere? Because it's a more deterrent system if you introduce also criminal sanctions, notably the introduction of jail sentences. Well, question is, does that lead to, and then we come back to our usual equation, that deterrence is detection times sanction. And so, let's look at the two elements for deciding how we can optimize both. Okay, so let's go through certainly one element. And if we're looking at detection, and you might say, well, we talked about the ICN, we'll talk about it in a minute again. 140 jurisdictions are now looking at these kinds of manifestations of bad business behavior. If you're in a cartel worldwide, you're at risk in all of these jurisdictions. Now, part of those 140 are the combined, of course, so you can maybe on a European case, you can subtract a few from there because we operate as one. The ECN operates as a single authority to the extent possible, namely, we all apply EU law, so we apply the same substantive standard to any cartel case that impacts on trade between member states. Then we have the ability to exchange evidence and we can assist each other in Europe on inspections. Wow. We have a network notice that tells us, who will take a case. More than 3 member states involved usually goes to the Commission. Otherwise, member states can do on their own account, but usually one takes the lead and does the case for making sure it is tackled. We also have, to promote the facilities of coming in for leniency, a model leniency program in the ECN. And indeed, we are trying to move towards convergence on other aspects as well, fining policy so that, it doesn't matter for companies in a way where they are being investigated, because the outcome will be based on similar principles in terms of finding policy. And we have there the also the NCAs to demonstrate that it's a single system. They can take account for recidivism purposes of each other's decision. Very important, of course, if you want to maximize the deterrent power of what we do. But this, if you look at this for me is really all about the detection side. Okay, sanctions comes in all at the end, but this shows we have now, all these competition authorities, so now 27 with the Commission, all these competition authorities with all the manpower that we have in all the member states to detect and investigate cases, which is quite magnificent compared to the situation before 2004 or the 90s. And indeed, in my member state, there were a few officers in the Ministry of Economics who were dealing with economic crime. And of course, cartels were low on their priority list. Most cartels were just registered. It was all very nice and rosy, but there was no competition authority. It was only established much later on, or much later than the Commission's enforcement power. But now there is a fully fledged competition authority applying the rules and sanctions within the member state. So a very different scenario from a few decades ago. So here we have an ECN dimension, but we have to ensure, particularly where we work with parallel competences and we try to combine our forces, that we do it in an efficient way, so that we don't overspend, we don't overdo it, but certainly, and very importantly, that the risks, and this is important for the ENC notably, that the risk of being exposed to multiple enforcement don't lead to uncertainty for companies. And thereby they feel that once they get into the system, they might be tricked. So I apply in one member state, and then I find out the other member state where I didn't apply has started an investigation. Whereas I thought, my reference authority was that first one. So we need a system there that works, and we would therefore now a system of short form applications. So you go into one authority saying, I'm applying for immunity here, and I do a minimal application in other authorities, so I have my place in line. So if ever the investigation is picked up by the other authority, at least, and then all the evidence can be transferred there through the mechanisms of the ECN notice and the and regulation 2003. So ECN, very important for deterrence. International. So what happens internationally? And how do we try to make the system work better? Well, first of all, we try to work on better rules. OECD, but that's the club of the happy few, the economically developed countries, and they think more about bigger picture questions of policy direction. And one of those things is, if you look at mergers, is common ownership a problem? Yes or no? So equity funds which have small minority shareholdings, but they all take a stake in the same companies. Does that lead to a coordination of commercial behavior? Yes or no? Big policy question. What do we do with compliance in competition cases? And the US, for instance, has now moved to rewarding compliance, or at least it allowing for the court to impose reduced sentences. Then we have very practically the ICN, the International Competition Network. So if you want to set up a leniency program, how do you do it? If you want to do digital forensic investigations, what are the best practices? What software do you use? So you put the experts together, and it's a very practical form of information exchange between authorities, best practices exchanges, and it's the ICN plenary is a big circus. It's a virtual organization. The Bundeskartellamt is currently in the lead, but that leadership changes between the authorities every so many years. Then to help developing countries, UNCTAD. I once did an outreach program in Kenya where actually it was UNCTAD run, financed, and it's also to help authorities to establish themselves, and indeed with very often limited resources, help them, let's say, to get higher on the ladder of enforcement. And then you have the WTO, which was going to be at one stage in the 1980s, 90s, the forum of reference also for competition matters. But that really has been, well, it never developed really. The WTO is in a hard place currently because of the, even on panels for trade questions, the US basically pulling out, or at least Trump having pulled out of it and not recognizing the dispute settlement system as it exists in the WTO. So now, importantly, we have a number of bilateral agreements, notably with the US, Canada, etc., but all of them are really about good intentions to help each other, etc. Now, one of those things that we help each other on, and for instance, in the marine hose investigation, and people in the US have gone to jail on that, but we postponed the inspections of the Commission until the day that the US was able to go into a hotel, to wire up, in the next, sitting in the next hotel room, to wire up the lamps and the sprinklers and what have you with devices, and they recorded an actual cartel meeting. On the very same day, the Commission went in and raided the companies in Europe in the same cartel. So that kind of collaboration is certainly part of the spirit that is in the agreement with the US, with Canada, and also other countries, but we cannot exchange evidence with them. Now, I told you I would be soliciting some views. I'm going to try and do one now, for instance. And so what would be problematic? And put yourself maybe in the shoes of the Dutch executive of the airline company Martinair. Martinair Martin Air does charter flights to sunny places, Curacao and what have you, but they are also a transporter. They are a cargo company mostly. So they were involved in the air cargo cartel, one of the big cartel cases that the Commission did and the US did as well. Now, when we did raids and we collaborated on setting up of those dawn raids and the investigation in the US with drop-in interviews, they subpoenaed people, etc. Now this Martin Air executive is on the radar screen of the Department of Justice as having participated in the cartel, and their program is about getting everyone into US jails, also people who are outside the US. They're on the Interpol red list. So whenever they travel, they get picked up in an airport and they get extradited to the US. There you go. Now we are investigating the case and the US is doing as well. What would the executive think of the fact that we could freely exchange evidence, if it were the case, between the US and Europe? What would be a problem there? And might I say, vice versa. So who wants to come in on that? You know, this is someone who wants to defend their case. As Johan mentioned, you know, you don't look at what the evidence of the cartel. Well, yes, of course, but also procedural questions. And so, you know, there's a procedural question inside your EU court cases about evidence gathering and the unfettered gathering of evidence, etc. Well, taking that a bit further into a discussion or an exchange of evidence between a criminal system and an administrative system, what arguments would this lady want to raise if we were to exchange evidence between these jurisdictions? Now, you're at risk in the room, but also on screen. Then I will mention your name and then you will be forced to come in with an opinion. Okay, Jacob is making an attempt here. And please also those online, you know, come in with your thoughts on this. Jacob.
So I would start by saying that as a company, you're already in a much weaker position, but this way you would face not one, but two prosecutors, and there would be negative spillover effects for you because you would not be able to benefit of any procedural irregularities that would maybe be valid pursuant to EU law. Whereas in the US, if the standard there is different, they would be able to let those evidence through, and then you would still be hurt by that evidence, even though by, say, EU standards, you would be able to somehow eliminate that evidence. So I would say that it would be very beneficial to, say, the Commission, if the Commission were to benefit from evidences, but then the defendant in the cartel case would not be able to benefit of their own procedural rights, which they would be able to if this was an all EU case and there would not be this exchange of evidence throughout a different source, different procedure.
Very well, and I will comment on that. Very good input. So who has the hand up online, on screen? Someone whom I haven't heard yet. So I'm just going to pick and choose. So, you know, I was going to say the first one to raise the hand has full immunity. And that doesn't work very well among you. So maybe Andrea, can I ask you to come in? Maybe I don't see your picture. You don't have to put your picture, but do you want to comment on this this aspect of, you know, different systems and the exchange of evidence and the consequences that that can have on someone's individual life? Andrea, can you come in? There's an outright refusal, so you will get the full fine imposed on you. Maybe over to Theo. Can you come in?
Not sure if you can hear me.
And I'm explicitly picking up on someone who doesn't have the picture there. Not
sure if you can hear me.
Yeah, yes, come in. Sure.
Yes.
Go ahead.
So
Not a problem.
So I'm trying to to work
Yes,
through
so
the different points, and I think the difficulty here for the
I'm
defendant
trying
is that
to to work through the different points, and I think the difficulty here for the defendant is that
this would rather be a burdensome process with there would be a need for clarity in terms of which system is it
this
that
would rather be
applies.
a burdensome process with there would be a need for clarity in terms of which system is it that applies.
And in fact, the sanctions that would be applicable under which jurisdiction, I think that
And
is
in
something
fact,
that would not be clear from the onset.
the sanctions that would be applicable under which jurisdiction, I think that is something that would not be clear from the onset. Yeah, that's absolutely right. We're offering the last chance to Andrea to get at least some reduction of fines, but you'd have to come in quickly. Otherwise, I will take your spot. Okay, no answer there. So let's just continue. But that, you know, the input we've had is from both of you very good. And there's one other comment.
Yeah, might
Till-
be allowed to comment on them as well. I think because we had a quite similar case in Germany recently, which was not exactly about competition law, but which was about evidence that was gathered legally in another jurisdiction. Meanwhile, the same type of evidence gathering in Germany would have been illegal. It was the EncroChat affair. So sad, and I think that could be a matter in Europe. For example, if the US would gather information, evidence in a way that's legal in the US, but it will be illegal in the EU.
So I think all of your comments go to point a bit in the same direction, and taking the I forget what her name was now, but she has actually served jail time in the US. Martin Air company located in Amsterdam. A Dutch lady executive went to jail based on a plea agreement. Footnote: plea agreements are different from the Commission system of leniency and settlements because it's an all-inclusive system whereby you get a reduced fine because you offer not only evidence, but you also agree to settle the case and not to go to court. So it combines with both elements in it. Now, stepping out of the footnote, you know, this lady would have been under an obligation for her employer in Amsterdam to collaborate with the company in view of the reduction of fine that the company was aiming to get from the Commission, because you would be violating your labor contract if you were not faithful to the company. So, and also we can ask in our administrative investigation using dawn raids, for which there is no probable cause to, in a way, break and enter the company. So there's no criminal standard that we apply with an application to a judge before we can go into a company. So if that lighter regime of fact gathering can be used for gathering evidence, including statements by company officials, and then we transfer all of that to the US, where then in the US people could end up under a criminal system in jail, you get into the problems that Till described. You know, so is that fact gathering legal? But also, what does it do? What does it do to the system? Because people will no longer want to cooperate in our investigations. They will not want to come in for leniency if they see that this is the risk. Indeed, the opposite is true as well. If companies want to collaborate in the US or are subject to investigations there, they must cooperate. Witnesses can be subpoenaed if that enters into our investigation and lead to, you know, highly increased fines, whereas the same obligation does not exist here in Europe. We are in a problematic situation. Hence, what have we done in the ECN? Importantly, we catered for this problem, notably in knowledge of the fact that certain cartel infringements or certain competition law infringements are punishable by criminal law and even incarceration in certain member states, notably in Ireland. So how can we make the ECN system function? And there we have looked at the question that the information exchange is free, but can only lead to administrative sanctions on companies. And thereby there are limits on the exchange of evidence that can take place where the situation of an individual person is at stake. And if it does happen, the ECN notice foresees that such sanctions cannot be applicable then by the receiving member state if they get that information. So in the ECN system, we have catered for that problem by limiting the consequences of working with other systems, but internationally it doesn't work. So there we are limited in the information. So with the US, we can exchange evidence that we have in our position, which allows us to mount an investigation, but the actual collection of evidence when we go in and raid companies, etc., cannot be shared with other authorities. Only exception now, Switzerland, where we have a treaty allowing the exchange of confidential information, where we are doing the same kind of case and with certain restrictions on it as well. Again, having in mind those same incentives. Okay, so that gives you a bit of a flavor of the international problems that you encounter when you work an instrument that by definition involves companies from abroad and also individuals. So we talked about leniency in the international context. It was super important for the Commission at the time to align its policy to the US, amnesty and full immunity. Otherwise, you can never get a timing that is similar, and a CEO in a company to whom we'd have to say, oh yeah, in the US you got amnesty right away. But in the EU, you have to wait until the end of the investigation, 3 years down the line, before you know what your position is. Not good. You want clarity upfront, so we aligned that with the US model. And indeed, of course, you have two models, leniency, amnesty, but they both drive to the same goal. Question is also that you need to try and align on who can be in, because if you say a ringleader cannot, because that would be, the leniency tool is an investigative tool. It's not a thing that we have there just to compensate companies for their good behavior. We use it as a tool to get evidence on the table. But if then you say, well, so we separate that from the moral aspect of a tool. Is it honest? Is it just? Is it equitable? Is it fair to companies? Particularly if the ringleader of the cartel is the first one in the door, they get that full immunity and the others will suffer. Is that fair? Well, some thought no. And so ringleaders were excluded from getting immunity, which is in a way silly because the ringleader is probably the one with the best evidence. So we wanted that one to be in as well. There's one exception, which is, coercers. If you have really pushed others to be in a cartel, and we have evidence of that, then you have crossed the line of, provoking if you want. Now that is arguable as well, because you could say, well, coerce, the others let themselves be coerced. So, and then importantly, there are markers. We talked about that in the little role play thing that we did. And the US, they have a bit of a different approach there, also because they have, the individuals under pain of sanction who cannot lie when they come in initially, so they know what they have. And already the basis for the evidence is often stronger there, but simply based on declarations rather than actual evidence. Okay, so these are some elements in there. Voila, and then there's a whole discussion going on also today, and I have sympathy for that discussion because you used to, as a big leniency applicant, you would go to the Department of Justice in the US, to the European Commission, maybe the Canadian Bureau, and that will be it. Now, if you want to ensure that your client is covered for an international cartel, I mean, you have to go around the world in a flying circus that, you know, brings you to all of these authorities who want to see the witnesses, interview, etc. And is that still useful? And then aren't we getting to over enforcement, which is a strange notion. You know, the more people are deterred, the better. But is it necessary that all these jurisdictions, you know, take on the same cartel? And gas insulated switchgear was done by partly prior to accession by the Czech Republic, by us, South Africa, I think Korea did something on that as well. So, you know, that already showed you that in those days, it was a problem. Anyway, for leniency, it's important that the conditions are as aligned as possible to maximize the incentives for companies to come in, and notably for the first one in the door. I just say that to also make clear that there are strict limits on what the Commission can do. Information exchange, as I said, results from investigations, but also anything that we gather that cannot be disclosed to other authorities. Professional secrecy, very strong. But of course, we have, you know, the freedom to discuss it within the European competition network. Voila. Importantly, also in the leniency game, hopefully it came out. If a company comes in for immunity or leniency, they are in the driving seat. We don't tell them where to disclose, when to disclose, or what to do. The only thing is that we tell them in their best interests that if you come in, you might as well make sure that you are covered in other jurisdictions. And accompanied with that is our own interest to then get what we call a waiver. But when we ask for a waiver, it's a company who has to answer. They are in control, but we expect them to give us a waiver so we can start discussing with other authorities. Part also of the spirit of genuine cooperation, but we cannot force them, because at the stage of the application, companies need to know that they are in control. Okay, we won't dwell too much on national courts, but there is, of course, an important question. If we are under this confidential obligation and leniency is not spread out, and we don't, you know, offer, and we do these statements that you can enter into a commission machine, and then we protect you against private damages claims, shorter decisions, settlement process, so it limits, you know, what about then? What if the national courts start, you know, asking for the world, and then it gets all exposed? So then we are nowhere. So we have to have the courts with us, and there have been a range of cases where the Commission has intervened internationally, in the US as well, to make sure appropriate protections are put around information that comes or has been submitted into the Commission's file. Okay. Then okay. I mean, this really also brings you into broader questions of competition law enforcement, not just on cartels. But we had, you know, and well, let's see if we can make this still a little bit more interactive also with the people on the other side of the screen. But there is that question, you know, what do you really need? I mean, how much enforcement do you really need? If it's not enough that one authority sanctions and then, you know, the thing is exposed, you have recidivism, and then if they do it again, they know, you know, or do we allow something that is, you know, multiple, double jeopardy, if you want, type of enforcement? Big question also for criminal sanctions. A big question also for criminal sanctions, you know, because does one individual go to jail in one jurisdiction and then hops over to the next one and they have to serve another jail sentence there, etc.? Or, you know, how does that play out? And so far, the issue hasn't really come up. Also because, like in marine hose, what the US did is for two guys who went to jail in the UK, the US Department of Justice said, okay, since we are satisfied with the jail sentence there, we are not going to be prosecuting these guys as well in the US, but they could have done it. Also in the Nishikon case, they made an argument of ne bis in idem, the same fine being applied twice on the same conduct. But mind you, the ne bis in idem is only applicable when you have, and thereby I come to the last case mentioned there in the lysine cartel, you must have an identity of facts, an identity of the offender, but also the legal interests protected. Now, can someone tell me what that really means? If the European Commission wants to protect a legal interest by applying our competition rules, what are we actually protecting? What is the legal interest that we are protecting? I look in the room.
Undistorted competition.
Undistorted competition. Judith.
I would have said free competition on the market.
Okay. My question would be, which market?
EAA.
It's the EA market. So as we are using, and that's why we are using the turnover in the EEA as the benchmark for our fining policy, and the US uses US commerce, which thereby excludes the ne bis in idem problem or the double jeopardy, because we are not defending the same legal interest here. The interest we are defending is the EEA market by application of the European competition rules. So we get out of that debate. And the ADM case, did I mention to you the Matt Damon film? Did I or not? Okay, has anyone seen the movie? I think it's called The Informant. Matt Damon. Could be. But okay, there is so this is early cartel days. When I entered into cartels, this case had just been decided by the European Commission. A book was written about the case, and it was actually filmed, and one of the DOJ officials actually appears in the film as an actor as well. But these are the early tapes that are just sound recordings taken from an adjacent hotel room in the lysine cartel, where, and then you get these statements also from these officials, because the company said, they literally said against each other with the Japanese companies in the room, ha ha ha, someone said, oh, but you guys are my friends, the real enemies are the customers. So, and that's how they went about, the cartel. Now the case is, so the film was made, sorry, let me just pick that off. If I can, I probably just shut that. Now a movie was made of the book that was written about the cartel. Interestingly, and in the US, of course, the evidence and the nature of the evidence needs to be different. There has to actually be an agreement. So you see Anne Bingaman, played by, I'm not sure who, but she was the deputy at the DOJ at the time, who was actually sitting in that room, and she sort of goes, well, say the word, say the word, say the word. And it wasn't a four-letter word, but it was the word agreement or agree. They wanted those people to say, we agree on a price, and that would have slammed them into the violation of the Sherman Act. In that same case, so the commission also imposed fines on that case. People went to jail, the companies received fines. Anyway, if you ever want to watch the movie, because the movie is about kind of a schizophrenic guy inside the company ADM, who exposes the cartel to the DOJ a bit by chance, by luck, for the DOJ, because they were investigating some industrial espionage by Japanese companies, and then they discover that those same companies are actually in a cartel jointly, and it all develops from there. And the whistleblower, so the informant, actually went to jail in the end, because he not only told them about the cartel, etc., but then he also lied about his own role in the cartel, hoping that he would become the CEO of the company, which of course never happened, because he served, I think, a 3-year jail sentence. So anyway, but in that case, they fought the European fine by saying, we have already been sanctioned in the US, people have gone to jail, high fines, what have you, for the very same worldwide cartel. So you can no longer challenge this in Europe. And the court came out in the ADM case by clearly stating that, you know, the unity of the legal interest protected was not met, and thereby, you know, we're not in a name bis in idem case. Okay, few minutes and then we are done. Damages actions. Of course, notably leniency statements, very important, but there is strong recognition, and the Commission helps to defend also the fact that leniency statements should be protected. We've gone to US courts, we've done it in Europe, in Flyder, the National Grid case on the GIS cartel, coffee roasters, Donau Chemie, importantly, and it's all to protect leniency documents from becoming disclosed. Then maybe a last few minutes, I'm just looking at the, voila, okay, so we come, you know, just a few last slides, but, and this is still, you know, on this question, should we be moving to criminal sanctions? And now I get back to the elevator cartel, because I'm going to cut short a bit the discussion in view of time. Let's go back to the elevator cartel. So elevator cartels in different member states, is it one infringement, yes or no? I think the Commission in the end had one decision, but decided on various cartels. I think the Belgian Competition Authority did an own case, and the Commission goes to court itself against the cartel to claim damages. And actually the legal service initially came to us and say, can we have a look on your file? Your cartel file, because the lifts in the Berlaymont building where the Commission houses were installed at the time the cartel was up and running. So we've been overpaying. And they went to court in Antwerp against the cartel members. We, of course, said, no way that you're going to have access to our files. This has been established on very different grounds. If you want to build your cartel case, here's the cartel decision. You can use that as a title, but otherwise, in terms of evidence, on which contracts were inside the cartel collaboration, use the Belgian system to extract that evidence, but you're not getting it from us. In that case, there was, you know, a strong push in the same discussion that we, I think, had at the time on, you know, this is the, I mentioned the company Schindler was involved, of course, in the cartel with the others, and said, listen, this is rogue employees, and we've done all to prevent this. We didn't succeed, but you should still give us a credit for compliance efforts, reduction of fines. And in the debate, they said, by the way, why don't you simply have criminal sanctions? Because then you can put the culprits in jail. We told them not to do it. They do it nevertheless. We throw them out of the company, and you as an authority put them in jail. Much better, and it fits with, you know, the spirit of the time. It fits with other white-collar crimes. Article 83 TFEU actually allows the Commission to go in that direction and make a proposal to qualify certain violations as criminal. So my question is, you know, can someone comment? Is someone in favor of doing that? Yes or no? And I haven't mentioned the cartel case of elevators for nothing. And it's going to be part of the answer because it was an extensive cartel matter. So why would we want criminal sanctions, or why would we not want them? And we debated this a little bit before. And with that, I can almost jump to my last slide. And it all comes back to this. So keep this one in mind, you know, when you think about these problems, and also when you think about your involvement maybe in academic discussions or in strategy discussions for your authority, or if you want to make, you know, claims to authorities defending the interests of your clients, to say, listen, if you're going down this route, this is what is going to be happening to your system. So you don't even want this, and my individual client should not become a victim here. Okay, I'm departing a bit from the question, but why would we want or not want to impose criminal sanctions?
I think that might hinder people to use the leniency program, because if they are at risk to go to jail when they disclose information, then they might not.
Good point, and it's part of the answer, but my initial comment to that would be, no, like in the US, if we have sanctions on individuals, you would also have immunity, amnesty for individuals. So in the US, if you are the first one in the door, you get full immunity and full coverage for all your employees. No one goes to jail. So that's catered for, at least for the first one in the door. But your answer is certainly partly right, because for the second one in the door, this is already problematic, because they may not get full coverage, and thereby they have at least a residual risk of going to jail, and then the whole problem starts. Yeah, Judith? And anyone online, please come in, put your hand up. I'm watching you, even though you think not. I should look in the camera maybe more closely. Okay.
So I would say if you impose criminal sanctions to employees, then they won't cooperate anymore. And you often need them because they are the ones that have the information, because they are the ones that are talking in the room, and it's not the CEO or the CFO, who has the knowledge to detect the cartel.
Yeah, that combines with your answer already to say, well, you have a risk for these, and how does that translate into our need for evidence gathering? That's what we're after. We want the evidence on the table. Annabelle, maybe pass the mic. Yeah.
Maybe you want to apply criminal sanctions because then people will get more scared to get involved in a cartel from the beginning.
Excellent part, that's certainly part of the answer. It's much more deterrent. If Johan can go to his clients and say, guys, you're at risk yourself. And the guy from British Airways who went to jail in the US, he wasn't even involved in any of the cartel meetings. But they detected that, he was somewhere aware that his employees were implementing it. And he had sort of said, oh yeah, well, I don't want to hear about this. So it was by negligence, basically, that he was pulled into the cartel. So, but yes, Annabelle, much stronger deterrence from it. So, but okay, to keep the suspense going a bit. So for me, detection, or you could say sanction, but if it's not applied, if it's not sustained in court at the very end, you're at risk of creating something which in the end doesn't work. And now that's why I've always said you need to look at enforcement systems in their entirety before you want to offer some good advice, which the US did a lot of in the 2000s, to say, guys, we should all, leniency, super, but let's all have criminal sanctions because, that's much more strong. And you see, that's what really drives leniency, amnesty applications. Now, let's take us back to the claim in the elevator cartel, which was dealt with by the Advocate General, who looked at this claim for compliance. Should it be rewarded? Particular circumstance not taken into account. And they said, the company said basically, oh, these were rogue employees. And then she looked at this and said, well, actually, that argument doesn't really work well, because it's your responsibility simply to respect the law. And how you want to do that is your business. But let's take a closer look. Over the years, 23 employees of this company were involved in the cartel. The evidence bears out that throughout the years, Mr. X, Y, and Madam Z were involved in all this. So 23, we have 4 companies in the cartel. Let's say there are 80 individuals who should then become subject of criminal sanctions. You can decide on the principle, the application will be national. You have to go to national courts. You have to have prosecutors, then prosecute these kind of crimes, bring it to convictions, have the national judges actually, put people in jail, what have you, and we're looking at, let's say 80 people to do that with. And then they can appeal, and they can go to the highest court, and they will go to the court in Strasbourg to plead their case. So We are now 15 years down the line and we still don't have any firm convictions, let alone, you know, that judges would actually even convict. And luckily in the Marine Hose case, the British judge said, okay, well, you know, I guess so. But in the British Airways case, the Virgin British Airways cartel, for a procedural element, the judge threw out the case, basically commenting that he would never even think about convicting people to jail for such a, you know, a violation of economic, you know, administrative rules. So, you know, you can think about these things as saying, oh, well, nice, you know, more deterrent. We have a possibility, you know, let's go for it. But if you think down the line, it's going to completely, you know, make your system grind to a halt because people will no longer want to collaborate with you in the investigations. You create disalignment between the company's interests and the individual's interests. Our fact gathering will go down the drain, and there's going to be, you know, lots and lots and lots of trouble. And in the US, and I'll stop there, the big difference, look at your system, the Department of Justice does the cases always when it's a federal case, and they decide whether to plea bargain or not. And they have that leeway. So out of the X individuals in a cartel, you know, 23 out of the 25 get plea bargain away, and they go to court maybe on 2 of the individual cases where the guy or the girl doesn't want to settle. So they control that whole system and therefore can make it work. And you know, if we had the same European way of working with but we don't. The Commission doesn't have jurisdiction over individuals. We can only go against undertakings, and that's a treaty provision. So we stopped where we started. We started with the treaty. We end with the treaty, and I think as regards cartel enforcement, we basically did everything in between. And I, on behalf of Johan as well, who had to be on a call, I thank you dearly for your participation. We have Valerie, who has helped us and guided us through this part of the course, but I certainly thank you for making the effort of coming to the classroom. It's much nicer for us to have live people here, which doesn't mean that I also am not, you know, full of recognition for those having hopefully stayed awake in different time zones or in different locations across the EU or elsewhere. So thanks again, and yes, indeed, if there are still questions, then please, and I see, by the way, sorry, Vivian has asked a question there, limitation period for the damages. And I think it is indeed from the final decision. Answer that I do not know is whether or not, but I think it is when the court case has become final. So when you appeal the cartel decision of the Commission, even at the ECJ, it's not final until it's final. At least the court has said so, until we decide. So I think that is the benchmark for that. But I'm only 72% sure on that. So take that with a grain of salt. All right, I see Beatrice, you still have a hand up. You want to come in?
Yeah, sure. I wanted just to ask. Oops.
If you want to come in, you have to put your mic.
Yeah, sure. I wanted just to ask. Oops. Are you listening to me?
Yeah, good.
Like how bound is the European Commission on disclosing the leniency documents to like how bound is the European Commission on disclosing the leniency documents to the private damage actions?
Well, I think the basic line is that if you make leniency statements, we protect them. And we only use what we really need for our final decision, and then parts of that may become public in the final Commission decision. But what the company should know is that pre-existing documents that they may have had and which are ordered by adverse parties in a private damages suit cannot be protected because they have been used in a leniency application. So any any previously existing evidence could not be protected. All right. Then we are, well, I hope to close a little bit early, but we're still before 6, I think. So if there are no other questions, then thank you all and have a great weekend and rest of the cartel or rest of the competition course. So thanks. Cheerio.